Have you settled down, Judge Adams?
I have DCJ, thank you.
Good morning.
Good morning, DCJ and members of the JSC.
How are you today?
I'm okay, thank you. Just a little nervous.
No, you don't need to be. Okay, let's get right to it. You hold a BProc degree from Wits University,
Yes, I do.
and you got a Best BProc Graduate of the Transvaal Award for that.
I was nominated for the best graduate for that particular year. I didn't get the award in the end. But
Oh, you didn't?
I was one of the nominees.
Okay.
DCJ.
What motivated the nomination? Were you a brilliant student? What was that about?
I suppose I was just above average, and the marks in my exams were above average, yes.
All right. But you did not further your studies thereafter?
I didn't. I started my LLB, but then I started my articles at the same time.
You went straight to the sidebar, and you remained there.
And then then the one thing led to the other. I then prepared for my exams, my admission exams, and I was just kept so busy in practice that I never really had a chance to further my studies.
Yeah. And you worked your way up such that by the time you ascended to the bench, you were managing partner of your firm.
Indeed, DCJ, yeah. By the time I left, I had been there for I think about 26 years. And by then I had been a partner for about 10 to 15 years or so. And I had been the managing partner for also about 6 years or so.
Yeah. What kind of practice did you run? What kind of work did you do?
I personally had a general practice, but my focus was litigation and trial advocacy. I did a lot of the court appearances on behalf of my firm in the High Court. Obviously started off in the Magistrates Court, and then later in the High Court I did all of the court appearances. And my firm had a big RAF practice and personal injury division, and most of my work was in that field. But I also did a lot of other work outside of the RAF work, including commercial type matters, that general practice type of work.
Yeah. And you became a judge in 2017.
January 2017, DCJ.
So you've been on the bench for what, 5, 6 years?
Over 7 years.
7 years, yes.
Yeah. 7 years and 3 months.
Had you acted before your permanent appointment?
Yeah, before my permanent appointment, I had acted in the Gauteng division, and the total number of weeks I seem to recall was just over 30 weeks in total, which included one whole term in the year before I got appointed.
Yes. And you have had occasion to write judgments during your tenure at the High Court.
Yes,
Some which have been reported.
indeed, DCJ. Yeah, I think I mentioned when I was here in October, by then the total was in excess of 300 published judgments. The total reported ones was, I think, over 10. Yeah.
That's a huge output, I must say. Uh, I see that of all those judgments, only 3 have been overturned on appeal.
Yes, yeah. I think last year particularly there were quite a number of judgments that had been upheld that I had written. They may or may not have been included in my list. They were towards the end of the year, yeah, which is
Yes.
quite encouraging.
Yeah. And in 10, you were upheld,
Yes,
including by the SCA. You have acted at the Electoral Court since November last year?
my appointment was effective the 1st of November 2023, DCJ. And immediately after my appointment, I started receiving from the chairperson matters, and I set to date, I set in 3 matters, was involved in a number of other matters which needed to be decided on the papers. Yes, so I have been acting in that court since the 1st of November of last year.
Have you written a judgment?
I've written one judgment, and sorry, I wrote one judgment, and I was part of the panel that wrote the judgment that came out last week.
Well, the first one, you have not submitted both of them to us to have a look at.
I know that they were published on the one that I wrote was published on the
Well, I can excuse last week's one, but what about the other one?
yeah. I think that one was also towards the end. It was towards the middle of February. That's in fact, it's ironically called the February matter.
Yeah.
But yeah, sorry, I just omitted to submit that particular judgment. It's on Safely as well, DCJ, in addition to being published on the SCA website.
Well, it would have been nice to have it in your bundle. So we
yeah.
know that you can write. You've written pretty good judgments for the High Court. I have no doubt that you do the same in the Electoral Court. But it would have been nice to have one in hand, in hard copy, to check.
I can't agree with you more. Now that I'm sitting here, I should have actually submitted those to the JSC.
Yeah.
And I apologize
that's all
for
right.
that.
Well, it's big. You still new in that court. It's big election year.
It is, yeah.
One can safely predict that things are going to get extremely hot. Are you up for the challenge?
I think I am, DCJ. It's already, and Chief Justice Zondi will confirm that the matters are just flowing in at the moment, and it really is a big year. It is quite exciting times for electoral court judges. It's the pressure is there. It's a lot of work, and it's a lot of matters, and they obviously need to be attended to urgently. And I think I'm up to the task.
You listed a few reserved judgments in your questionnaire. Have you managed to deliver those?
Yeah, all four, I think it was 4 judgments, all 4 of those have been handed down very shortly after I submitted my application.
Okay. You disclosed a health condition. Well, it's no shame. You have high blood pressure and high cholesterol, which many of us suffer from. Do those hamper the execution of your judicial duties in any way?
Not at all. I don't think so, DCJ. It's under control, and I see my medical practitioner on an annual basis. And yeah, I think it's all under control. I'm on medication for both conditions.
I ask because I also suffer from high blood pressure because of all the stress. And despite a healthy lifestyle, it acts up. So, in addition to the medication, I would advise you to go hard on exercise and make sure you eat well.
No, I do. I try and keep fit from time to time. I also do some road running from time to time, DCJ. So I do keep that in check. And like I say, I religiously take my medication like clockwork.
All right. Thank you, Judge Adams. I'm going to hand over to Chairperson Zondi to put questions to you.
Thank you, DCJ.
Okay. Morning, Judge Adams.
Morning, Justice Zondi.
I see you submitted your application to the JSC in November 2023. That's the date on which it's,
Oh, okay, yes, yeah.
It's 12 of the bundle. And then the judgment that the DCJ referred to, that is the judgment of February, which involved the leadership dispute. That judgment was delivered when? Was it in February or? That is after you had submitted your application.
Yeah, it was, I think, in the first or the second week of February, because we heard the matter at the end of January, and the and I prepared the judgment a week or so after we heard the matter.
Okay.
Yeah, so it was like I think the second week of February.
And then, since you joined the Electoral Court, where we have been involved in a number of cases, and more especially between March and now, we have received more than 20 applications. Some of them involving the nomination.
Yes, yeah.
Okay.
Yeah.
And you participated in all those cases.
In all of those matters. In fact, we also sat in a hearing last week, Friday, involving consolidated matters.
Yes.
Yeah, it was last week, Friday. Yeah.
Okay. And as the DCJ indicated, as at October last year, we had written about 300 judgments.
Yes, in excess of 300. I think they've gone to about 340 now since then.
And in addition that, I see that you had also written some articles and which were published, one of them in the Hearables. Is that correct?
That's it, yes. Yeah, that was whilst I was in practice, Justice Zondi.
Okay. Thank you, DCJ. I've got nothing further to say. Thank you very much.
Thank you, Justice Zondi.
Thanks, Justice Zondi.
DP Pete?
Thank you, DCJ. Good morning, Judge Adams.
Morning, Justice Betsy, Deputy President.
I would like to take you through the questionnaire.
Yes.
At page 4, paragraph 16.1 in particular. Let me know once you are there.
Yeah, okay.
Thank you.
I don't know if this is electoral court vacancy. No, this is feedback.
It's paginated page 7 of the bundle.
Yes, I'm there,
Thank
Deputy
you.
President. Yeah.
Paragraph 16(1), the caption is, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant. You have listed the judgments. But the second part as to why you consider those judgments significant, speaking for myself, you haven't dealt with that at all. All what you have said, this is what the case was all about. This was a review of a regional magistrate's decision. This one was about public procurement. And one needs to troll through your judgments to determine whether the matters are significant or not. Isn't that a serious omission?
Yeah, now that you mention it, Deputy President, maybe it is. I suppose I assumed that by looking at the very short summary, one can see from that what the significance is. For example, ILEX, the very first matter, dealt with public procurement, and whilst I had set aside the award, I thought that it would be inappropriate from a remedial point of view to set aside the contract. Sorry, whilst I declared unconstitutional the award of the contract, I thought it would be inappropriate and unjust to set aside the contract. But yeah, I hear your criticism, Deputy President, and I accept it.
Because those are the type of cases which appear before our courts day in, day out.
Yes, yeah.
And you don't tell the members of the commission why you regard that is the one where you wrote judgments to be significant.
Yes.
That is the principle which they propounded or enunciated or clarified. Thank you. I'll leave it at that.
Thanks, DP.
Thank you, Judge.
Thank you.
Thank you, TPPC. Any Commissioner Dodo?
Thank you very much, DCJ. Good morning, Justice.
Good morning, Commissioner.
Good. You were here 6 months ago.
Yes.
Yes, in October last year. And you were somehow not successful. And I remember that one of the concerns was that you lacked the experience or exposure to the electoral court, and now you have acquired it, and you are an acting judge at the level of the electoral court. But there are concerns about you. Some of the people have raised some concerns. One is Deshan Modley, who lodged an objection about your candidature. He says that he made an application for a rescission of judgment, and is of the view that you are biased and you are unfair. How do you respond to that?
I actually responded formally to that
I want you to formalize it now.
That objection. So Mr. Woodley was.
Excuse me, Commissioner Dodov and Judge Adams. Can I just find out from the complaints committee if they considered this objection and what their verdict was?
Yes, Deputy Chief Justice, we did. We dismissed it. This is a complaint that is coming for the second time. We dismissed it last year in October. We dismissed it now. It has also come as a complaint to the JCC, and it was dismissed by the JCC on the 7th of April. So it's been dismissed 3 times now.
Well,
in the light of that, you want him to formally explain, or should I go to the next question?
To the next question. Well,
or to the next question.
Since it's been dismissed, there's no objection before us, practically.
No, in the light of that, it is okay. Now, since you acted as a judge at the Electoral Court to date, what are the outstanding cases that you can cite that you presided over? And what lessons have you learned out of that, out of those cases?
Commissioner, I haven't presided over any of the matters because of the fact that I'm obviously not one of the senior panel members, but I've been involved in the matter in which I was allocated as the scribe by the chairperson. That's the February matter. And that matter dealt with the jurisdiction of the Electoral Court in relation to disputes, internal disputes in political parties, factional fighting, and that is the judgment that I wrote. Obviously, the point about that matter is that the Electoral Court is intricately involved in the disputes relating to leaderships of political parties. It forms a very important part of the jurisdiction of the Electoral Court. In addition to that, of late, we've been involved in the matter relating to the registration of political parties and the fact that the procedure that one needs to follow in terms of the Electoral Court, if you have an objection to the proposed registration of a political party, the procedure to be followed. And if that procedure is not followed, then in a way you're non-suited. Also been involved in a matter fairly recently relating to the special votes overseas. And I've learned that, I understand the position and the procedure that one follows as prescribed by the Electoral Court. So those are the issues that I've been able to learn from my experiences.
And where you sit, you can confidently say that you're finding your feet, you're getting all right, you're getting the necessary experience and exposure as a result of that short stint that you had at the level of the Electoral Court.
I think I have, Commissioner. I most certainly think so. I definitely don't profess to know everything about electoral law, but they say that the next best thing to knowing something is knowing where to find it. And I understand what the legislative framework is, and I'm also familiar with the important case laws, the case law relating to the important principles in electoral law.
I thank you, DCJ.
Commissioner Nyambi?
Thank you, DCJ. Morning, Judge Adams, on this side.
Oh, sorry, yes, hi, Commissioner.
As they've indicated that we interviewed you last October. So in your view, what is the significance of the Electoral Court in upholding democracy?
I think importantly, Commissioner, the underlying constitutional principle relating to elections is the political rights enshrined in our Constitution, the right to vote and the right to stand for public positions. The Electoral Court has a duty to ensure that those rights are protected. And importantly, the Electoral Court duty is to ensure that the principle relating to the requirement that elections must be free and fair, and that principle is implemented by the Electoral Court, who's required to deal with those type of issues as and when matters come before it. Because ultimately the main criterion in electoral law matters is a decision whether or not an election is free and fair. And if the court is of the view that that is not the case, then it needs to take the correct remedial action as it did in the CUM matter in 2013, where the by-elections were set aside. So in sum, I believe that the contribution from the Electoral Court is ensuring that that constitutional principle is complied with by the IEC and by the other arms of government.
Thanks. My last question. When we were here last October, there was that strong view from the commissioners that you needed to have some opportunity to act. And now we are sitting here, we have had that opportunity. Do you think that decision then was unfair? You were ready then, or you are more than ready now? It was a wise decision from the commission.
Yeah, I think it may have been, with the benefit of hindsight, not a bad idea that I was given an opportunity to act, and that I was basically given a chance to just get a bit more experience. Because if the truth be told, up and until that point, I had very little exposure to electoral court and electoral matters. Although, as I indicated in my interview in October, that I had a keen interest in electoral court, and that interest has just been reignited by my involvement in the electoral court. It truly is such an important part of our everyday life, and it relates to such a fundamental human right that I said last year, that's quite exciting to be involved in this field on the part of the judiciary.
Thanks, Judge Adams. Thank you, DCJ.
Thank you, Commissioner.
Commissioner Club.
Thank you very much, DCJ. Good morning, Judge.
Morning, Commissioner.
Thank you very much. Parliament, in our context, consists of two houses, NA and NCOP. How are members of the NCOP elected?
Sure, yeah. I understand that the members of the National Assembly are taken from the, they appointed from the list, the party's list that you submit to the Electoral Commission before the elections. I also understand that as far as the NCOP is concerned, that those are appointed by the legislatures of the provinces, who are appointed directly from the lists of the political parties for the provincial legislatures.
What is the main function of the NCOP as distinct from the NA in the lawmaking process?
Yeah, I think the NCOP is in a supporting role to the National Assembly. Their purpose is distinct from the lawmaking processes of the National Assembly. Although they, like I say, they in a supporting role to those. They deal with very specific issues that is dealt with in the legislation.
Can you explain it in terms of the competencies of each of the two houses as it relates to lawmaking process? In other words, why in the lawmaking process do we need an NCOP?
Yeah. I must be honest, Commissioner, I'm not really familiar with that particular field. I know that obviously our primary lawmaker is the National Assembly. I would take a guess and say that the NCOP, its lawmaking competencies relate specifically to the provinces, but I may very well be mistaken.
Okay, thank you, Judge. Thank you, DCJ.
Commissioner Steinberg.
Morning, Judge Adams.
Morning, Commissioner Steinberg.
I just want to follow up on the question that Deputy President Petse asked you, the Alex case. You didn't actually tell us why it is a case of significance. His view was that it's a bread and butter tender review. Why do you think it's a case of some significance?
Well, the answer that I gave to the DP is that I thought that and I know that there's been a lot of cases on this point, in fact, by the Constitutional Court, for example, that is a lot more significant. But I thought the significance lies in the fact that, as happened many times before, the award was declared unlawful, but the just and equitable remedy ordered that the contract was to continue. So it may be, now that you mentioned it, that it's not as significant as I thought it is. But in the bigger scheme of things, I thought that it's significant. I can't take it any further than that, Commissioner, sorry.
Okay, it just seems to me that really is something that happens every day in the courts. So,
Yeah, true.
But that's your answer, thank you.
Yes.
Commissioner Marumogai?
Thank you very much, DCJ. Good morning, Judge.
Morning, Commissioner.
I agree with you. This is probably one of the most important areas that deals literally with our everyday life. And when I was preparing for this interview, I saw that there are so many acts of parliament that your court has to consider at different intervals. Sometimes national elections, sometimes municipal elections, and all. And I got confused somehow in between as to which act really applies when. And I just want clarity with respect to that. Normally, when you're talking about the Constitutional Court and you ask somebody what is the jurisdictional elements of that court, it's like constitutional matters and arguable points of whatever, those two legs. When we talk about the Electoral Court, if somebody says, how does this court assume jurisdiction on a matter? If I'm a potential litigant, the member of a political party, or I have political interest and I want to take a matter to that court, what are the jurisdictional elements that I should concern myself with for me to be able to properly be before that particular court? Because we saw even in the cases that were heard over the past week, the issues of jurisdiction came to light, and they proved to be very important. What are those jurisdictional elements that one needs to concern themselves with to bring the matter to your court?
Yes. Thank you, Commissioner, for the question. I think the jurisdiction of the Electoral Court is spelt out in the Electoral Commission Act, obviously as regard based with having in mind what the Constitution says about it, but in sum, the Electoral Commission Act deals with the jurisdiction of the Electoral Court. Importantly, the Electoral Court is empowered and required to adjudicate electoral disputes in relation to decisions made by the Electoral Commission. Importantly, the Electoral Court has the jurisdiction to review decisions of the Electoral Commission on the basis of parja and or on the basis of legality and rationality. The Electoral Court also has the jurisdiction in terms of the Electoral Commissions Act to adjudicate appeals from decisions of the Electoral Commission, as well as deciding, like I indicated earlier, disputes between internally in political parties relating to leadership. But in sum, the jurisdiction of the Electoral Court comes from the enabling legislation, importantly the Electoral Commissions Act.
Can I just follow up on that, DCJ? And I'm asking this because I'm purely confused in terms of my research, and I don't really know what sort, and I'll take your word for it. And what is the role then of the Electoral Code and the Electoral Act? I'm not sure, is it still in force? Is it still applicable?
No,
Because when I went through it, it seems like it does provide jurisdictional elements to some extent. What then will be the issue if there is a conflict between the act that we've just referred to, the Commission Act, and this Electoral Act? What will then be, to the extent that there is a conflict?
Yeah. No, Commissioner, the Electoral Court deals with mainly procedural issues relating to elections. It makes provision, for example, that the Electoral Commission is to prepare a timetable, etc. It deals with mainly electoral issues. The Electoral Commission Act, and there's, as far as I could see, there's really no conflict between the two pieces of legislation. The Electoral Commission Act deals with the constitution of the Electoral Commission and the Electoral Court and the powers of these two bodies, whereas the Electoral Act itself deals with the elections, the procedures that one follows before, during, and after an election. But it really relates to electoral procedural matters, whereas the Electoral Commission Act deals mainly with the Electoral Commission of SA and the Electoral Court of SA and its powers.
Thank you very much, Judge. Thank you very much, DCJ.
Commissioner Magonish?
Thank you very much, DCJ. Good morning, Judge Adams.
Good morning, Commissioner.
Just two quick questions. On what day will the mandate of the National Assembly expire and that of the NCOP?
On the 29th of May, 2024, unless the President changes the date of the election.
And the MPs will be competent to act until what time? Or on which day, until which date?
I think until the next administration is appointed. But in terms of the legislation, it must be within 90 days from the 29th of May.
The NCOP?
The same applies to them. I think.
At what point does a president of the country ceases to be a member of parliament?
On his appointment as the president.
Okay. Yes. Thank you, DCJ.
Commissioner Singh?
Thank you very much, DCJ. Good morning to all commissioners and admin support, and good morning, Judge Adams.
Good morning, Commissioner Singh.
Yeah, my first question will just relate, it's a query actually, your reserve judgments that you listed in your application. Have you dealt with all of those?
I did, I most certainly did. Okay. Like I indicated to the DCJ, they probably were handed down within a week or two after I submitted my application.
Thank you for that. In the last interview, you spoke of, and we referred to the New Nation judgment. And you also spoke about it now. It was a seminal judgment, for electoral and the way we conduct elections and who can participate in the South African electoral system. Now, without traversing on the jurisdiction and the separation of powers, looking at the separation of powers between Parliament and the judiciary and the executive, do you think that Parliament went far enough to accommodate what you all had considered in the New Nation judgment as far as independence participation is concerned?
What subsequently happened, Commissioner Singh, as you know, is that we've got the OSA, the judgment by the Constitutional Court that dealt with the amendments to the Act, and the COBET well, the finding by the Constitutional Court was that as far as the amendment to the Electoral Act is concerned, that was inadequate in the sense that as far as independence is concerned, the requirement for supporters or list of supporters was too high, and the Constitutional Court, no less, was of the view that needs to be dealt with by Parliament. Obviously, it can't be done before present elections, and they had indicated that particular provision was not properly dealt with. But other than that, the Constitutional Court has indicated that as for the rest, all seems to be above board, and the Constitutional Court seems to be happy with what Parliament has done, and I tend to agree with that.
If I may continue, DCJ, Parliament had to give effect to ensure that independents can participate. Are you aware of the Electoral Matters Amendment Bill that came before the NA and the NCOP recently, and do you know what those amendments entailed?
I can't say that. Is it recently? Is it after the Open Nations of SA matter?
Yeah, it was 3 weeks ago, I would imagine, that the NA considered it, and a few days later the NCOP considered it. It hasn't been signed into law by the President, but are you aware of what the amendments were to the Electoral Matters Amendment?
I can't say that I do, Commissioner Singh, no.
Again, my last question would be, through you, DCJ, is that you were one of 5 in a panel with ANC versus the Electoral Commission matter. Now, how significant a role...
Sorry, which matter?
ANC versus the Electoral Commission.
Oh, yes.
You're one of 5 members in the panel. Yeah. What role did you play, significant role, in the court reaching that judgment, and what legal principles applied in that particular matter?
Yeah. Commissioner Singh, I wasn't involved I was involved in the MK versus IEC at ANC matter. I wasn't involved in yesterday's matter. Is that the one you
yes, okay.
Yes, okay. Yeah, the principle in the ANC matter was a procedural one, and it specifically relates, as I indicated earlier, to the registration of a party and the Electoral Commission's duty to follow the right procedure. In that particular matter, and the important principle in the matter was that the Chief Electoral Officer has a duty to register a party upon application. And the issue in that matter was simply whether the Chief Electoral Officer had before him an application for the registration of the MK party, and we found that it did. The objection, as far from the ANC side, we found ought to have been done in terms of the Act. It required that if you have an objection to the registration of a party, once the proposed registration is published in the Government Gazette, you have 14 days within which to object. If you don't object, then for all intents and purposes, you are non-suited, in a sense, to object further to the registration of that party. And once that party is registered, then there's not much that can be done other than to review the final registration, which is what the ANC attempted to do.
Thank you very much. Thank you, DCJ.
DCJ, could I just do a follow-up to the second question of Commissioner Singh? Judge Adams, can I just ask you back to your knowledge of the current legal position insofar as the amendments are concerned? Some of them were debated in the one movement case, one SA movement case. that was decided in December
Yes.
last year. But it's really in relation to the changes to Schedule 1A, because that's the schedule that tells us the composition of the National Assembly post the inclusion of independent candidates.
Yes.
What will that look like?
Commissioner, my understanding was that it related specifically to the recalculation in the event of an independent resigning or retiring or dying, and I seem to recall that the Constitutional Court was of the view that those I don't know if
No, sorry, I don't
yeah.
want to interrupt you.
Yeah.
I'm not asking you about the judgment.
Oh, okay.
I'm asking you about your knowledge of what the current electoral laws are. In particular, the changes that were brought about by the Electoral Laws Amendment Act.
Yes.
Some of them were debated in the judgment, but what I'm asking you now is the big change is in the composition of the National Assembly by Schedule 1, capital A. Now that independents are in the mix, what will the National Assembly composition look like? At the moment, we know it's 350 minimum up to 400, all made from lists submitted by political parties.
Oh, okay.
At the moment, what will it look like after the 29th of May?
So we will have 400 members of parliament, Commissioner. 200 of those would come from political parties, and the other 200 would come either from political parties or from independents. I don't know if that answers your question.
Well, what about the so-called compensatory seats? I thought that's what Commissioner Singh was talking about, that the big complaint is on the compensatory seats that still favors political parties.
The compensatory seats would then also be split between the independents and political parties, Commissioner.
Thank you, Decision.
Are there any questions from the colleagues on the virtual platform? No. That brings us to the end of your interview, Judge Adams. Unless you have any questions for us, you're excused.
I have no questions, DCJ. Thank you to you, and thank you to the members of the JSC.
Thank you for coming.
hearing me. Thank you.
Good morning, Judge Jacob.
Good morning, DCJ.
I hope you're well.
I'm very well, thank you.
May we start?
Yes.
Okay. Uh, you studied music,
I did.
and then after obtaining a whole degree in that line, you decided to pivot to law.
Well, I got interested. I was trying to avoid following in footsteps, which is why I studied music, also because I love music. And then I accompanied my father in the constitution drafting process, and I got interested. And it didn't let go after that.
Well, it seems to have been an inspired decision because you did so well in your academic studies that you obtained, you passed your LLM summa cum laude.
I did, yes.
That was in international business law.
Business law.
All right. And then you started your legal career as a researcher,
I did.
as a law firm, then for the Land Claims Court,
Yes.
to which you would return years later as a judge. Then you joined the Joburg Bar
Yes, in 2003.
and remained there for what, about 15 years?
15 years.
And during that time, you seem to have immersed yourself deeply in the business of the Bar Council and the GCP, playing various roles there.
I did because I still believe that the governance of the profession is so important to the transformation of the profession, to making it accessible, and also to providing legal services to the public.
And you were also a member of the Advocates for Transformation and NADEL.
And Nadal.
So what kind of work did you do as an advocate? What kind of practice did you have?
I think about 70% of my work would have been constitutional and administrative law. And the rest of it was a nice little mixed bag. It wasn't as varied as I would have liked, but it wasn't a complete specialization either.
And you penned a couple of articles.
Just a few. I focused more on the work.
So you were appointed as a permanent judge in 2019?
With effect from January 2019.
Yes.
Oh, yes, you're right. Sorry. All the years are mixed up in my mind. Yes, I was interviewed in October 2018, and I was appointed with effect from the 1st of January 2019.
And since your appointment, you were seconded to the Land Claims Court as well.
I was, yes.
And you have produced a number of judgments in both the High Court and the LCC.
Yes.
How many judgments would you say on estimate you've produced?
Yeah, I didn't actually keep count, but when I realized that the question was being asked by this commission, I had a look, and I think it's somewhere between 250 and 300.
You've been overturned in 4 on appeal.
4 that I know of. The problem is that we don't get informed when we get overturned or upheld. So unless we come across it, or unless when we do the search we find it, it's very hard to know.
Yeah. But then you've been upheld in another 4, according to your questionnaire.
Yes.
So it balances out.
Yes.
Have you acted at the Land Claims Court, at the Electoral Court?
I am currently acting in the Electoral Court, yes.
Since when?
From the 1st of February this year.
All right. You have had various stints. Well, you started out at the Land Claims Court and you've had various stints in that court as a judge. One would have expected you to have more interest there rather than in the Electoral Court. Why are you interested in the Electoral Court?
I've always been interested in the Electoral Court. In fact, I was tempted to apply to be a non-judge member, even when I was a member of the bar, but the timing was never quite right for me. And I have always wished, since this particular vacancy has been advertised a few times, I've always wished that I was in a position to apply for this court, because I think that the Electoral Court serves a function that is very important, because the elections are a cornerstone of our democracy, and the Electoral Court is there to serve the function of being part of the process of ensuring that the elections are what they are intended by the Constitution to be. And that's why I am interested in it.
In your short time in that court, have you had an opportunity to sit in any matters?
I have. I've participated in 3 matters. One, I wrote the judgment, but we determined it on the papers in chambers.
Which one was that?
The National Freedom Party matter.
I'm subject to correction, but I scanned through your papers. You have not attached it, have you?
No, because I've only acted in this court since February this year, and the application was had to be in last year. And
But it is possible to supplement one's papers before the interview.
I was not aware.
You didn't know. No. All right. So can you just tell us a bit about that judgment?
That one was a challenge. So the National Freedom Party, unfortunately, has been subject to a lot of leadership disputes in its short life. And before the previous 2019 election, there had been an agreement which had been made in order of court, which allowed the 2 factions to contest that election. Then, unfortunately, they did not seem able to agree on their own internal leadership processes. And so the factions were accusing each other of not being the correct leadership. The IEC then, took the position that it would not recognize anyone until the matter was determined by a court, because it was before a court. And then after that, there was a new election in that party. The IEC then decided to acknowledge that the product of that election as the proper authority of the party, and a person from the other faction then challenged that decision of the IEC. So that's what that judgment dealt with.
All right. And what was your finding?
The finding was that the challenge did not have any basis, primarily because the person did not have locus standi. They brought the application as the NFP, but it was clear that they didn't have the force of either faction. But also because there was no merit in it. It was a question of what was the effect of an application for leave to appeal. They had appealed a judgment setting aside the election of that faction. And they claimed that because they were appealing it, that it meant that they had to be recognized. But we found that all that the noting of the appeal did was restore the status quo ante, which was where the IEC said we're not going to recognize anyone until a court determines it.
You mentioned 2 other cases. Can you tell us about those?
Sorry, I didn't hear.
You mentioned 2 other cases.
2 other cases that I sat in. One was, I think it was 2 weeks ago, the application by the Democratic Alliance against the IEC to allow international voting at consulates headed by honorary consuls. And the other one was the one which was heard on Monday, which dealt with the inclusion of the former president on a candidate list.
I understand that only an order has been...
In both of those, the reasons have not yet been provided, because we thought it was important we agreed on the order, and we thought it was important to provide the order urgently because the reasons are not quite ready.
Well, I can tell you that the country is waiting with bated breath for those reasons.
Yes.
Speaking about agency, the Electoral Court, as you would know, you would have experienced by now, is a high-pressure court, especially during election periods, and you're expected to hand down your decisions super quickly. Now, I'm a bit worried by a declaration you yourself have made in your questionnaire that you had trouble delivering your judgments timeously. Have you managed to sort that out?
I've sorted that out, and also the trouble was never with urgent judgments. Urgent judgments were always handed down urgently. It's the ones where I had to put them aside to think about them that got me into trouble. But I have sorted out that. I've managed to figure out how one balances one's life as a judge in order to deal
Well,
with
you
that
did say
workload.
that was during your early stages as a judge. So you
Yes,
found
and
your feet now.
I have now found my feet. Thank you.
Okay. You also disclosed a chronic health condition, and I raised this as I did with the previous candidate, because wellness in the judiciary is just not given the seriousness it's actually neglected, and we have seen that has serious consequences for judges and service delivery, because judging is grueling work, and if you have niggles, then that affects your work performance.
It certainly does,
Yeah.
DCJ, and that was part of what I was trying to figure out when I was first appointed, how to deal with all of that. I now exercise regularly. There are it's not negotiable. This is the time when I go for my walk. This is the time when I do those things so that I can function at my best and deliver the best to whoever needs it.
All right. All right. I'll hand over to Justice Zondi to put questions to you if there's any.
Thank you very much, DCJ. Hi, morning, Judge Yaku.
Good morning,
You
Justice.
joined us in February 2000 this year.
Yes.
That is after you had indicated your interest in applying for the
Yes.
vacant position.
Yes.
And I see that ever since you have participated in a number of matters that we had at the Electoral Court, more especially those that are dealing with nomination of candidates.
Yes.
And the question that was put to you by the DCJ is why are you now interested in the Electoral Court? I see that in your questionnaire, paginated page 12, paragraph 20, the last paragraph 20, you express the similar sentiment that you have always been particularly interested in the mechanics of how elections take place and how election disputes are adjudicated. So basically, the question reflects what you had stated in your questionnaire. Is that correct?
That's true, Justice Zondi.
You completed the questionnaire on the 27th of November 2023, and the NFP case judgment, when was it delivered, by the way?
It was, I think it was in March sometime. Okay. Yeah.
So that was subsequent to
Yes.
the completion of your questionnaire. I see that we have also produced some papers which were published in a reputable publication. Is that correct?
Yes, but very few. That's never been my focus, and I don't pretend to be an academic person, unfortunately.
Thank you. All right, I've got no further questions. Thank you, DCJ.
Do you have any questions for the candidate colleagues? Commissioner Klaber?
Thank you very much, DCJ. Good morning, Judge.
Good morning, Commissioner.
Thank you. Under what circumstances does a member of Parliament cease to be eligible to serve as a member?
Cease to be eligible.
Correct.
Well, if one of the elements in Section 47 of the Constitution comes to light, then they're no longer eligible. For example, if they become an insolvent, they become declared of unsound mind, they are convicted and sentenced to more than 12 months. If they become the president, I can't think of more right now.
For a councillor, I'm now taking you to a municipal level.
Yes.
Under what circumstances does a person who stood as an independent in one lose his or her membership of council?
Commissioner, I would have to look in the Local Government Municipal Elections Act. So I haven't looked at that particular thing. I can look it up now if you wish. But I would imagine if that similar provisions would apply, because if someone becomes declared of unsound mind while they are a sitting councillor, they presumably would also become not eligible. But I will look that up in the Act.
Maybe I can spare her of that question if you allow me, CJ, to ask another question.
Yeah. I may just point out that it is not an open exam exercise.
Well, DCJ, it shouldn't be an exam at all, because when we're in court, we have access to our papers and to our legislation.
Yeah, and the textbook questions can really throw you off. I know.
You allow me, CJ, to ask another question. Thank you very much, CJ. Our Constitution allocates functions to different spheres of government.
Yes.
National, provincial, and local. Which therefore means that the executives in those spheres are competent to act in those functional areas.
Yes.
For unallocated functions, the residual powers, who has the power amongst the different or between the different spheres?
The residual powers belong in the national sphere.
Thank you.
Yeah.
Thank you. That's answered.
DP President.
Thank you, Deputy Chief Justice. Good morning, Judge Jacob.
Good morning, Deputy President.
At paginated page 10 of your bundle, under paragraph 16.3 and 16.4, you have listed 4 of your judgments overturned on appeal and 4 confirmed on appeal. And the proposition that I want to put to you is that from what you have provided us with, yours is a borderline case.
Deputy President, I don't think that the question can be whether you were always upheld on appeal or always set aside on appeal. The reason that the appeal process exists is specifically for this reason, that it's a safeguard, it's a safety net. A puny judge sits as a single judge and is only human and can make mistakes and must learn from those mistakes. I certainly don't think it should be a balancing exercise of you were right in 4 of these and you were wrong in 4 of these, so it's a borderline case. I've handed down many judgments. Most of them have not even gone on appeal. So as far, I don't think it would be fair to use the words a borderline case at all.
But there would be cause for concern if most of your judgments are upset on appeal.
Deputy President, I think it depends, because if all my judgments are upset on appeal, yes, there would be cause for concern.
Thank you.
But I don't think that the fact that there are judgments upset on appeal is in itself cause for concern, because otherwise we're saying there's no reason for the appeal process whatsoever.
Just give me a moment, please.
Let us just wait for the noise to abate. Where is
very
it coming
loud.
from? See now?
Is it rain?
We don't want the ceiling caving in on us suddenly.
Oh, well, we can't switch the rain off.
No. Should we continue, colleagues? Are you as hard of hearing as I am? Okay, let's continue. Just try to speak as loudly as we can.
I will try, thank you.
Okay.
Thank you, DCJ.
Commissioner Dodo? Oh, sorry, I thought she had finished. Carry on, DPPC.
Shall we then go to page 8 of your questionnaire?
Yes, Deputy President.
Paragraph 16.1.
Yes.
The one that asks you to list judgments that you consider significant. You have listed them, and the reason why you consider them to be significant.
Yes.
And from what appears from the questionnaire, what you have recorded, that has left me none the wiser. I don't know why you regard those judgments as significant.
I apologize, Deputy President. I put in what I thought was important about those judgments, and if that did not come through, then clearly I did not explain well enough. I'm quite happy to explain now if you wish.
No, you didn't even begin to deal with that issue and state why you consider them to be significant, what principle was propounded, what principle was explained, what principle was overturned, for example. Because
well, for example, Deputy President, the last one, the principle that was established by the judgment is that when eviction in terms of the Prevention of Illegal Eviction Act is delayed by court processes and doesn't take place on the date determined by the court which granted the eviction order, a fresh date must be determined in terms of the act by the court, and fresh notice must be given to the person who is being evicted. That is the principle that is set in that judgment. And I'm sorry if I didn't explain it enough in my explanation.
Thank you. Thank you, DCJ.
Well, luckily for you, the General Counsel of the Bar has given us snippets of some of your top judgments, and they gave you a glowing report on those. So we are assured that you can produce good judgments.
Thank you, Deputy Chief Justice.
Commissioner Dodo.
Thank you once more, DCJ. Good morning.
Good morning,
Advocate Yap.
Commissioner.
I want to, in the first instance, follow up the question that DCJ posed to you regarding your reserve judgments and the length
Yes.
of delivering your judgments.
Yes.
At the moment, to be precise, how many outstanding reserve judgments do you have?
At the moment, 3. And all of them were reserved in the last couple of weeks.
Okay.
And for how long?
2 or 3 weeks.
No, I mean, for how long have they been reserved?
2 or 3 weeks. From last term, just a couple of weeks, they've been reserved. Am I not answering the question?
I don't hear this.
Sorry, a few weeks.
No, I mean, the last time that I'm told, because now I'm a novice here, legal novice, but I'm told that at least 3 months is acceptable
Yes.
to deliver judgment.
Yes.
And your reserve judgments have been reserved for how long? Is that
You
4
mean
months, 6 months, a year?
currently
2
or
years?
other ones?
All of them
All
that
of
are
them.
reserved currently, that are outstanding.
That are currently outstanding.
Yes,
2 or 3 weeks. I don't have anything over 3 months.
you don't.
No.
Okay, thank you very much then, DCJ. The next question, I want to ask you about the Electoral Act, which I consider to be the Bible of the Electoral Court, your court.
Yes.
Now, 4 years ago, the Concord made a declaration of invalidity so far as the Electoral Act is concerned, pertaining to the participation of independent candidates to the elections.
Yes.
What are the features of this, or what are the implications of this in your view in respect of the elections, especially these elections that we are going to hold in the next 6 weeks?
I'm sorry, Commissioner.
Sorry, just before you answer, I'm really struggling to follow the proceedings. Can someone just tell them to switch off the air conditioner? We don't need it.
I also didn't quite catch
Just wait a bit, because
Yeah.
I will also help you to rephrase the question.
Thank you.
Yes, okay.
Well, I'm told it's centrally operated, and someone has been phoned to switch it off. It may take a bit of time. Let's chug along and just try to speak loudly.
And I will also try my best to be slow so that you hear me well. I mean, the judgment of the Concord heralded a new epoch
Yes.
in our country in terms of the elections
Yes.
by introducing the independent candidates.
Yes.
Now, firstly, what else has been introduced as a result of the judgment of the Concord? What you know?
I'm sorry, Commissioner. My mind's gone blank on what's been introduced.
Let me try to simplify it. I was dealing with this matter for the last 4 years, and I'm the one who requested extension because of the complexity of the process itself in Parliament.
Yes.
Advocate Nketobi has talked about compensatory seats
Yes.
as a result of that.
Yes.
What do you understand with that?
Compensatory seats are, as I understand it, the seats that are allocated by the allocation of votes where, so each seat is worth so many votes. And if a person gets less votes than one seat, or votes that are left over after the number of seats has been allocated, then in terms of the proportional representation system, those votes then get allocated to proportionally to the parties who have got the votes, so that people get extra seats. And the Constitutional Court found that part of the Act, which doesn't really cater for independence, still to be constitutional.
Yes, it's okay. The second part that we were declared invalid by the Concord was the issue of the political party funding. What do you
Yes.
understand? What do you understand with regard to that? Because there are two areas: equitable, as well as the other one that I will tell you now. But what do you understand with regard to the political party, the formula for political party funding?
Well, I understand that there's been a new bill passed recently which deals with political party funding and also funding for independents. I have not looked at the bill. And I know that there are provisions which provide for parties to get funding according also to the proportions of their representation. But I haven't looked at the specifics and the mechanics of that. And obviously, if a matter comes which is within the jurisdiction of the court which deals with that, or to the High Court, then I would look at it. And
No, it's okay. If you have not checked that, it's okay. I was going to follow up the question in respect of the equitability and proportionality. That must be taken care of.
Okay.
With that, thank you very much, TCJ.
Commissioner Singh?
No, thank you very much, TCJ, and good morning, Judge Jacob. Commissioner Dodova has made it easier for me in terms of the question relating to are you aware of the Electoral Matters Amendment Bill? I think you referred to it, that was passed by
Yes.
the two houses
Yes.
recently and not signed into law as yet by the President.
Yes.
And are you aware that there are a number of NGOs, about 21 of them, and 10 of the 13 political parties that have written to the President asking him not to sign certain sections of the bill into law, because some of the amendments that were proposed in the bill and passed by the two houses are substantive in nature and not consequential to the new nation judgment.
Okay.
Is there anything that you're aware of in that regard?
I was not aware of that, no.
No, then I... No, thank you, DCJ. No, she's not aware of the matters that I'm referring to, so I don't suppose I can take it any
further?
Yeah, thank you.
Commissioner Marumachai?
Thank you very much, DCJ. Good morning, Judge.
Good morning, Professor.
I have one question for you, but before I do that, I just want to comment on this being overturned on appeal and all those kind. I think you should not feel bad when you are overturned. I mean, if you have written close to 300 judgments and only 8 are taken on appeal and only 4 is overturned, really, that is not an issue that you should really be overly concerned about. And even so, the court that appeals, that overturns you, sometimes the judgments that are coming from there are shocking. sometimes you find that even when they overturn, when you read the judgment. I mean, yesterday we dealt with one. In the previous interviews, we dealt with Modau judgment, which was recently corrected by the Constitutional Court. Sometimes we just get shocking judgment. So I don't think it's something that you should be overly concerned about. When I was preparing for these interviews, I got really confused with the legislative framework that is applicable in electoral law. I saw in one legislation it says, first and foremost, it appears as if the electoral, and correct me if I'm wrong, electoral court appears to be an appeal court. It seems like it's an appeal court, you appeal to it. And I saw one of the provisions saying there's no review or appeal to the decision of that court. But I saw the Constitutional Court having to decide the matter is coming from that court. I just want to understand what will be the basis for an appeal to take place from that court to any court in South Africa, based on what I've done. And I just want to get clarity on that sort of framework, because I'm very confused as to how it operates.
Yes, Professor. The Electoral Court has jurisdiction over electoral matters, but it's not exclusive jurisdiction except for a few things which are specified in the 3 acts that govern it. Then jurisdiction is given to the other courts, the magistrates' courts and the High Court, also to deal with electoral matters apart from the exclusive jurisdictions. Now, if you go to those courts, you can then appeal from those courts to the Electoral Court. The Electoral Court is only a court of final instance, as I understand it, when it deals with a dispute regarding the breaches of the Electoral Code. Otherwise, you can still appeal from the Electoral Court to the SCA or the Constitutional Court.
Thank you very much. DCJ.
Commissioner Steinberg?
Thank you. Good morning, Judge Jacob.
Morning, Commissioner.
I am sorry to bang on about the question of time it takes you to write judgments, but in this court, time is of the essence, so we do have to be satisfied that the problem is solved. You had mentioned, that there was a particular period when you were struggling, and that was, it was evident, it was that 2019-2020 period. However, when I look at the GCB's report, they say that at the time of writing their review, which was this year, there were still 3 outstanding judgments, 2 from August and 1 from November, which means that the August, no?
I don't think so. If I can just check. But yeah, you can carry on. I'm not sure which ones they
I can
are
tell
referring
you.
to. Thank you.
So they say the Paleng v. Davey, which was reserved on 30 August 2023. Oh, sorry, that's yes, and then In Re Valverdin Community, August 2023. Then there's one from November 2023. Certainly in the case of the first 2, that would still be well over 3 months.
Yes, that was over 3 months.
Yeah.
That it was an appeal judgment, and it needed a little bit more consideration. And then with the Velferdent one, I actually made a mistake. I should have listed it under part-heard matters because it was not actually ripe for a decision yet. And in fact, I had received further submissions in that matter from one side 2 weeks ago, and I received an email this morning from the other side asking for an extension. So that one is actually a part-heard matter, not an outstanding judgment. When I put it on that list, I made a mistake that the matter was ripe for decision, but more submissions had to still come in.
I also see that there are a number of judgments which were reserved late 2022, November 2022, that were only delivered in July 2023. For example, S.O. Mujahi versus Minister of Police and Zubair A. Haji versus Mohammed H. Darsot, for example. That again is after the period where you were having trouble. Likewise, Button Joshua v. the state. So,
Joshua?
Button Joshua versus the state.
That judgment was actually given extempore in court. Then there was an issue with the transcript. They requested the transcript very late.
And the other two that I mentioned that were in November 2022 and only delivered in July.
I'm trying to. So what was the first one?
Mujahi. S.O. Mujahi.
Was that one of the? On which page do I find it?
This is not in your.
Is it in? You said it was in the GCB.
No, this is just additional.
Oh, okay. So that must have been one of the unlawful arrest ones that was in November 2022. So 2020. Yeah, it had a few issues that needed me to apply myself, and it was very, very busy. So it had to wait. I had to, in terms of juggling things, I had to prioritize things which were more urgent. And so that one I had to add it onto the pile. And so it had to take its turn.
And the Haji v. Darsot?
If I can just check which one that is. We deal with so many matters, Ms. Steinberg, that I can't really remember everything by name because, there are just so many. Mm-hmm. If you give me a moment, I will check which one that is. You say it was in 2022.
Yeah, you reserved on 23 November 2022 and handed down on 27 July 2023.
Sorry, my computer's taking a moment to respond to me. That's actually incorrect, Commissioner. The judgment was handed down on the 27th of, yes, you're right, 27th of July. It was the date I signed it, But the judgment was handed down on the 23rd of November. It was an extempore judgment, and the transcript came to me late. So the judgment was actually handed down on the 23rd of November. It was heard on the 22nd of November, and I handed the judgment down extempore on the next day.
Okay, so it's really just the one that you said you'd put on the pile.
Yeah, and that's the problem, is once you start putting things on the pile for consideration, you have to do them in order. And if you've got, and there isn't time in the High Court in Gauteng, there isn't time to fix a backlog until you have a break. And I didn't have a break until the second term last year. And when I did, I fixed the backlog.
It's a concern I raise because I really do appreciate the extraordinary pressure that the Gauteng judges work under.
Yes.
And, I salute you all for doing it. But all the judges are under the similar pressure.
Yes.
And some meet the deadlines and some don't. And we just have to be sure in the case of the Electoral Court that the judgments have to come out fast and furiously, or the whole point.
Yes, I
Justice
understand
works.
that. Absolutely agree with you.
And you're now confident that you're able to do that.
Yes.
Okay, thank you.
DCJ, I just want to follow up on this line by Commissioner Steinberg. I think hopefully mine will be less controversial, Judge Yacob. It's because it's on the list you submitted, page 10 of the bundle at item 16.5.
Yeah.
Now, if you look at those judgments, there are 8 of them dating to the 24th of July, 2023 to the 9th of November, 2023.
Yeah.
And then if you look at page 12, that's the date you signed the form, which is the 27th of November,
Yes.
2023. Now, does this mean, as at the 27th of November, 2023, those judgments were outstanding according to those dates?
Yes, that is correct.
All right, thank you.
Thank you, DCJ.
Commissioner Nyambi?
Thanks, DCJ. Good morning, Judge.
Good morning, Commissioner.
As a person that has acted in that division, if you can share with us immediate challenges that you have experienced that you think if you can be appointed, they need some immediate attention.
I think one of the challenges is the question of where the court sits, because we don't have, the court doesn't seem to have its own dedicated logistical support. And I think that could be a challenge, but perhaps it was only a challenge for the last 2 hearings that we had because they took place during the recess of the High Court, but in the High Court building when a lot of people were on leave, so we had trouble with support. I don't know that I've been there long enough yet to experience other challenges.
Thanks. My last question. In your view, what is the significance of the Electoral Court in upholding democracy in our beloved South Africa?
Well, the significance is that it's a special court which is dedicated to electoral matters and which has special rules which allow it to deal with matters quickly and to provide certainty as quickly as possible so that the elections can be free and fair and consistent with the Constitution. It's a safeguard to make sure that this can happen.
Thank you, Judge. Thank you, TCJ.
Commissioner Notice, did you have your hand up? Okay.
Yes, Mr. Mangen.
Then
Otherwise,
it's Commissioner Mangen.
even if I have, I'm happy with the candidate. She's doing fine.
I see that Henna Dell membership all those years ago is working for her right now. Commissioner Mangen?
Thank you, DCJ. Good morning, Justice Jacob.
Good morning, Commissioner.
Yes. You are aware that the commission, the IEC, it's required by law to publish an election timetable.
Yes.
And that is for a particular reason.
Yes.
Because if that timetable is not followed, elections may actually not take place, may just be delayed. Now, my understanding is that part of the function of the Electoral Court is to enable the Commission to have finality on disputes that would arise during the electoral process.
Yes.
Now, you said that you were part of the panel that said yesterday.
On Monday.
On Monday, yeah, and you deemed it necessary to issue an order without reasons on a matter that it's by and large known to be very urgent, because I've just checked on the election timetable. The IEC is required to issue certificates to candidates by the 12th.
Yes.
Do you, now with retrospect, do you think that it was appropriate for the court to issue the order without reasons, knowing fully well that whoever is aggrieved by the decision may need to weigh his or her options in terms of what the next course of action would be?
Well, Commissioner, the problem was that the matter was heard on Monday. It took the full day. The judges, the panel conferenced and made a decision, but the electoral timetable required the decision to be handed down by yesterday. So we had to give the decision. We did not have time to articulate the reasons, and those will be done as soon as possible.
Yeah, well, we do know that for an appeal lies against the order and not the reasons. Fine and good. But for a litigant to decide what to do with the order, to appeal it or not, it is important for that litigant to understand what the reasons are. So there are instances when the order without reasons does not help. And this may just have been one such case, but I accept the explanation. I want to believe that you wouldn't want to comment further other than what you have said.
I can't comment further.
Okay.
Can I follow up?
Yes, Prof.
Mangen, I'm not sure whether you was done.
No, with regard to this one, I was done. I have a second and last one, which is not a very complicated issue. Can I finish it?
Maybe let's exhaust your first one, then move on to your...
Yes, mine is more of a comment. I think I would imagine that under the circumstances that we are dealing with and the period within which we are at, it will be more prudent to issue out an order and make sure that the parties have certainty. Then the judges will deliberate on how then the reasons will come so that the process can move forward. I think the order cannot be delayed because that's the most important thing. I'm not sure if you have comments on that, but I think...
That was the motivation of the panel as well, in addition to complying with the electoral time date.
Are you answering for the candidate, Professor Marumaka?
No, I'm just commenting on the deliberation.
Okay. Proceed, Commissioner Mugeni.
Thank you, DCJ. My second and last one. It is my understanding that the court also deals with irregularities that arises on the election day.
Yes.
And it is a requirement for the elections that a voter should produce an identity document to the presiding officer or presiding officer on the day of the elections. To your knowledge, does the IEC accept electronic identification?
I don't believe so. I believe that you have to produce your physical document, either your card or your green barcode.
Is that the position, or that's what you think should be the position?
No, well, the last time I voted, that was the position, and I'm not aware that it has changed.
Yes, but if it may well be that this matter has not arisen as an irregularity, but the same way that people use their phones as a means of identification when they are at the airports or they're driving, wouldn't you think that the time may have come for the IEC to consider electronic form of identification?
Well, it may have, but as far as I know, they have not. Okay. And of course, they would have to make sure that they're able to verify it properly. And I'm harking back now. The Constitutional Court, before the second democratic election, gave a judgment about why it was appropriate for the voters' roll to be limited to those who had the green barcoded ID documents, because previously in the first election, you could use anything. And they said it had to be because you could verify, and if you didn't have the barcode, it wasn't on the right system, and so on and so forth. So if they do update it, they're going to have to make sure that it's whatever new ways they use, it's going to have to be properly verifiable to avoid voter fraud and so on.
Thank you, Justice. Thank you, DCJ.
Commissioner Mokwane.
Thank you, DCJ. Good morning, Judge Jacob.
Good morning, Commissioner.
3 quick questions. The first one, how many times are parties allowed to replenish their lists per year?
To replenish their list per year? I'm afraid I don't remember.
Okay, thank you. When is the term, in fact, on what date will the current cohorts of members of the National Assembly cease to be members of the National Assembly?
The Constitution provides that the National Assembly ends the day before the elections, so it would be the 28th of May. The term ends on the 7th of May, but then the Constitution provides for them to be extended until the day before the elections are held.
Thank you. Then the last one, once a person has been appointed Deputy President, does he or she ceases to be a member of the National Assembly?
I think it is only the President who ceases to be a member of the National Assembly.
Thank you very much.
Do we have any questions from the virtual platform?
No, thank you, Deputy Chief Justice.
All right, thank you.
No, thank you.
Okay. Do you have any questions for us?
I have no questions. Thank you, DCJ.
Well, in that case, this is the end of your interview. Thanks so much for making yourself available.
Thank you very much.
And you're excused.
Thank you.
Colleagues, we have a strange program for today. We are supposed to take the tea break, then come back for deliberations, then we should not take a very long time, and then have lunch. I had a discussion with the secretariat about that, and I was wondering, we have two options. We could go straight to deliberations and be done with that, and then go for tea, and then start interviewing one of the candidates who is available, and then take lunch thereafter because others are not here yet. Would you? Okay.
I supported condition. We have just 5 minutes stretch break.
Stretch.
CJ.
I support that we deal with this now, but 5 minutes was, there's a change, that's what we can do as we are having other members getting out, so that could be that 5 minutes.
Yes, it works out.
But we deliberate now.
Yeah, okay. Don't go far. Let me first welcome Judge President Hendricks from the Northwest Division of the High Court and the Premier's representative who is joining us virtually, Honorable Malloy. Welcome, colleagues.
Thank you very much, DCJ.
Yeah. Good afternoon. Is it afternoon yet? No, still good. It's still morning. Good morning.
I was just making correct. He's the acting premier.
Oh,
he's the acting premier.
I overlooked that.
Sworn by the judge.
My humble apologies. Welcome, acting premier. Yeah, I was assured that he is connected. Mr. I'm sorry, just help me. How do you pronounce your name? I hate it when people mangle my name. I don't want to do that with yours.
It's not a problem. It's Matsitse.
Matsitse.
Yes.
Right. Good afternoon. Oh, good morning. Still a few minutes to noon.
Good morning, DCJ.
How are you?
Fine, and how you see DCJ?
I'm fine, thanks. Well, you appeared before this commission not so long ago. It was in October 2022. Yeah, so
correct.
you are not a stranger here. We know you, and I don't expect that there'll be many questions for you. But you never know. Don't hold me to that. We remember you for your many academic qualifications. You have a DPURIS, an LLB, 2 Masters of Law, and a string of diplomas.
That's correct, DCJ.
And you are a regional magistrate of many years.
From 2015, that's correct.
From 2015.
Yes. But acting before in 2010.
Mm-hmm. And you have acted as a judge for many years now.
Yes, from
since 2016.
That's correct. DCJ.
And since October 2022, have you had an acting stint in the High Court?
Yes, I did have an access in 2023.
For how long?
For 6 weeks.
Mm-hmm. So what does that make the total sum of your acting period in the High Court?
I think it makes 58 weeks.
All right. And we know that you have written judgments, some which have got you in trouble because there were complaints from the law bodies and the commissioners that you did not take particular care in the quality of your judgments before you deliver. You do not proofread. In some, that was the charge.
That's correct, DCJ.
Mm-hmm. During your recent stint, did you have a chance to write any judgments?
Yes, that's correct, DCJ. I think 2 that have appended, Molefe and the other one.
Mm-hmm. Well, it seems that your latest efforts have not earned you pardon because there is still a complaint from the GCB, for example, that your work is sloppy, for lack of a better description.
That's correct.
Would you like to address?
That's correct. Let me just start by saying that that judgment also, it's the one that the same or the period that the foreshare, the one that made me put me in trouble the previous time, and it was appended on the same period. But I would like to say again, I really apologize for that, and it's regrettable in that regard. And I have, as I've indicated, improved or tried to improve very much. During that period that I was doing, I appended the said judgment. I did not teach myself, I was not yet taught very well about computers, in the sense that nowadays I know now how to structure in a sense that, like, for example, you start the numbering, for argument's sake, like in this case that I was doing them manually instead of allowing the computer to follow up if you enter or did, let's say, on a computer setup as such. So I really, really apologize in that regard. I won't, I take it that since the last time I've improved in that regard. Thank you, DCJ.
Yeah, I just, let me first ask, what is the status with your second LLM? Have you acquired it?
No, not yet.
Not yet.
I'm now on the proposal. I'm busy with the chapter on the first chapter in that regard. I've been asked to finalize it this year.
Yeah. No, I just wanted to express I fail to understand how someone is so scholarly would be accused of producing work that had basic mistakes such as grammatical errors, typos, and all that. It just doesn't tally with what I perceive you to be.
I do understand, DCJ. It's sometimes I'll say what caused that in most probably it was because of pressures. And I think when I did the judgment on that one, it was the time that I went back to the office and with regional court where I'm stationed, you have a lot of work that one has to do. It's not an excuse if I put it that way, but however, it was during the time that one has to, you find that you've got three trials, postponements, and many matters. And then when you get the chance to do that, when you read your judgment, when I'm doing it after hours at home, you find that I take it for granted that I'm at this paragraph and this, and then at the end, when I'm supposed to submit it, when I read it as if, or automatically it's on my mind. But really, in that regard, I apologize. That's why I'm saying this judgment that has been said or that I've made a mistake. It's during the time that Foche was also involved, because the same GCB previously, they were happy with my judgment and everything in that regard. But I do, as I say, DCJ, I apologize. And it's an error that I take it that I won't do it again, or it's not going to happen.
Well, there is another error I want to point out to you in your questionnaire, your application form now, the very first page, paginated page 4 of the bundle.
Page 4.
Page 4, yeah, where you state your personal details.
Personal details.
Yeah, section 1 of the JSC questionnaire.
And page 4, it's the previous.
The heading is section 1, personal. That's
the first page.
Yes.
Okay.
Section 3 requires some personal details.
Oh, this one. Thank you. Sorry. Oh, page 4. Yes, I found it. Thank you.
You have not stated your date of birth, your place of birth, importantly, and your citizenship. And if you had not appeared before this commission before, I would not know if you're a South African, which is actually critical for the validity of your application. Why did you not fill in those details?
I think when I read that think it should have been a mistake, say certain personal matters you can leave out. I think when I completed that, I deleted the citizenship, everything in that paragraph. I was not aware of that I've left it, the citizenship in that regard.
All right. So where did you act in 2023?
I beg your pardon, sir.
Where did you act as a judge in 2023? Your last acting stint?
I was
Where
in
was it?
I was acting in Pretoria.
In Pretoria.
Yes, DCJ.
So you still have not acted in the Northwest Division to which you seek appointment?
I've not acted, but I've raised my hand to the JP previously, the last time I was here in 2022, that I'm available to can act, and he did reply to say that he will come, or the secretary did reply that the JP will come back to you regarding that. I've raised my hand in that regard. Yes, I have not yet acted.
Okay, other than for that 6-week period you were acting in the Pretoria High Court, what else have you done with yourself since October 2022 that would enhance your standing as a candidate before us today?
Except not assisting in the aspirant regional magistrate who were appointed last year. I was doing lectures in that regard, and also assisting or whenever I'm being called. Like last week, I was called by the church at AME to come and lecture, or not even lecture, give a topic, discussion on GBV and domestic violence. So I've been trying to involve myself in the community as such. And besides that, I've been in my court in Boysens or Johannesburg.
All right, thank you so much, Mr. Masisa. Do you have questions for the candidate, JP Hendricks?
Yes, thank you, DCJ. Good afternoon, Mr. Matsitse.
No, it's good afternoon, JP.
How are you?
Fine, and how are you, JP?
Good, thank you. Can I also follow up on the questions by the DCJ?
Okay.
With regard to this application form. Do you have children? Do you have children?
Children?
Yes.
Yes.
Because that in 4.2, that is also not indicated.
It's not indicated?
Yeah, on the form.
I did not indicate this, as I indicated to DCJ, that the questionnaire, particularly when it comes to, they say, personal matters, one can not state them. But yes, I do have children, but they are adults.
Very well.
DCJ, sorry to intervene like this. Sorry, JP. Could that information be provided to us, please? The place of birth and the date of birth now, so we have an idea as we move forward.
Well, he is here. Will you please tell us when you were born and where you were born, and state your citizenship, please?
Okay. I was born on the 23rd of August, 1961 in Johannesburg, but I grew up in Northwest at Rustenburg, Phokeng, or Mosanton, as they call it. I attended school, primary school in that area. I also attended school in Phokeng. And
no, you don't need to go into that detail. So you are a South African citizen.
Thank you.
Are you a South African citizen?
I beg your pardon?
Are you a South African citizen?
Am I a South
African citizen?
I'm an South African citizen.
Okay. Thank you. Okay,
Yeah.
carry on, JP.
Thank you very much, DCJ. From your CV, it's clear that you will be turning 63 this year, isn't it? 63 years of age?
Yes, currently I'm 60. I'll be turning 63 on the 23rd of August.
Yeah, and you are regional court magistrate.
Yes, I'm
currently.
regional magistrate.
Yeah, and regional court magistrates retire at the age of 65. Isn't it?
Yes, you can sit
Still
until you are
apply.
65, but I think you can ask for extension until you are 70.
Yes. I was still busy with the application form. Can you perhaps go to paragraph, I can just find a place now. Paragraph 6 on page 11. Let me start there. Under the heading court experience.
Page 11.
Yes, page 11
Paragraph.
of the application form, paragraph 6.1.
Is it on the forms?
On the form, yes.
Because page 11, I don't know whether I'm on the correct one.
It's paginated page 14.
Page
at the
14
bottom.
on the page.
At the bottom.
Okay. There's paragraph 4.
Yeah, paragraph 6.
6. Do you appear in court? Yes, sir.
You indicate frequently. And then the question is, please give the details. And then you indicated, I do not appear in court as a practitioner. I preside in court as a presiding officer on a daily basis. Can you see that?
That's correct.
Yeah. But I'm interested to know, what is your experience like when it comes to criminal law, administrative law, constitutional law, labor law, or other civil law, as asked in 6.2?
Okay.
Perhaps you can give it percentages.
Okay. Currently in the regional court, that is, if that I'm appearing daily, it's criminal, it's let's say 60% to 70% of criminal work in the regional court. And administrative law might be not much, 1%, and constitutional law, nothing at the in court, and labor not also at all. But the other one is just civil work that we do. Regional court does civil work in that, divorces, actions, and all that.
Yeah, but during your acting stings in the High Court, what percentage of work did you do as far as, for example, civil work is concerned?
In the High Court?
Yeah, in the High Court, vis-a-vis criminal law.
Okay. If you look at my CV, I've done 26 weeks of criminal law, and I will say 32 weeks from the 58, 32 weeks of civil, but spread over, not specifically for one thing, like civil trials, civil appeals, and also opposed motion, and interlocutory applications. So if I group them together, it's as such 32 weeks. But mostly 26 weeks, it was criminal trials and also on the same criminal appeals in that regard.
And did you also in the High Court do more criminal work than civil work? Did you do unopposed motions?
I've done unopposed motion for about 2 weeks.
How many?
How many matters?
Matters, yes.
I wouldn't say, because let's say in Pretoria, one get about 10 matters in that week. Let's say I would say you get about 5 to 10 matters for that particular week that you'll be sitting on a motion, unopposed, and also in that regard, Johannesburg. So I can't give you, some will fall through, some will proceed in that regard. That's where some of the judgments that I've made are coming from the oppose motion in that regard.
Yeah. You know, the Northwest, 80 to 90% of the work is civil work in the Northwest. Unopposed motions, we now have a capped at 100, because at one stage there was 177 unopposed matters on the roll for a Thursday. The roll closes on Tuesday and then you get the files. I want to know, will you be able to cope with approximately 100 unopposed matters, having a day and a half to read?
If I get you correct, that 100 opposed?
Unopposed.
Unopposed. No, unopposed, that one I can, because before the JP changed the directives, in Johannesburg, one will get about 150 or 100, more than 100 for that, let's say, like you say, on Tuesday. Definitely, you'll sit on Tuesday, you'll get the 100 files. And also, when you came out of court, you'll get another 100 or 150 to that for Thursday. But nowadays, what happened is that with the new directive, one gets daily unopposed motions. So you get about, at the maximum, it's about 40 to 45, or in that regard. So on a daily basis, yes, I will be able to cope unopposed. And also, because with interlocutory applications also, you get 35, 50, 45 per day. So in that regard, I would definitely be able to can cope with load, caseload, and also with my experience, and also working under pressure from the regional court. And as a former, I've worked in asset forfeiture, I know it's unopposed, but because of motion, then I will say definitely as an attorney, I will be able to cope in that.
Yeah. You indicated in your application form that there were 2 cases,
Yes.
9.4, that leave to appeal was granted, but you don't know what is the outcome, whether it's finalized or not. Why didn't you inquire about?
I did. I even sent after getting this note, and from GCB, the query that in that regard, I tried to find out from the registrar of in the High Court in Johannesburg, and he said he does not have anything. He cannot tell me what happened to them at this stage. I'm trying to follow up. I even asked my former secretary in that court to follow up. So far, they have not yet come back to me.
Yes. At the time when you submitted this application form, you were acting as regional magistrate. You are a regional magistrate, isn't it?
I'm a regional
Yes.
magistrate.
Did you have any part that matters?
In the regional?
Yes, when you submitted this application form.
I
and
do
if so,
have-
how many?
I have part heads, as I indicated, that we have a lot of work. But so far, my part heads are about less than 7 so far.
Less than?
7.
Less than 7.
Yeah.
Thank you. I just want to point out one other thing to you, over and above, and it coincide, let me put it this way, it coincide with the grammar problem.
With
the grammar, the complaint,
Yes.
or the concern raised about
That
the
there was
grammar and the
raised,
spelling.
yes.
Yeah. In the judgment of Sarel Pietrus du Plessis versus the state, do you have that judgment?
That I've appended.
Yes. Yes. The first one.
Oh, the
Saro Petrus du Plessis.
The one of Mpumalanga.
Yes.
That's,
When you go to paragraphs 2, 5, and so on.
Paragraph
2, 5, 9. There's reference to a record. See transcript, page 2 to 5, for example. Paragraph 2. Paragraph 2 of the judgment.
2 to 5.
Paragraph 2. Let's deal with paragraph 2 first.
On offenses, the topics of
Yes.
Yes, sir.
Now, at the bottom there, you refer to see transcript pages 2 to 5. The same appears on paragraph 5. See pages 241 to 251 and 163 to 188 on application. Now, the reader of this judgment won't know because it won't be before the reader. Paragraph 9, see page 250 to 251 of the transcript. I don't know whether you attach the transcript to your judgment because the reader won't know.
It was not attached, JP. I do understand that I should have perhaps quoted the paragraphs in that regard.
Yes. Can I just run something else by you? And this is about the proofreading of the judgments before you append the signature and before you give it out. I see the judgment of Isaac Piet Mofokeng. The case number is 3163 of 2018. Do you see that?
Isaac Mofokeng Piet.
Yes. Isaac Piet Mofokeng, Visitor Road Accident Fund. Do you have that judgment?
Yeah, RAF, yes.
And the next judgment is an X Corporation Limited and Lawrence Maruas. Now, what struck me when I went through the judgments is it is the same case number, 3163 of 2018. Was this the same case or is it different cases?
It should be different cases. 3163 and 20, it might be the date of the last date, the year that should have amended in that, because they all come from Mpumalanga. I think that's where also I made the mistake in that.
Okay. Can I ask another question in the judgment about Isaac Piet Mofokeng?
Isaac Mofokeng.
Yeah, if you go to paragraph 3. It seems to me from paragraph 3 that the parties inform the court that no witnesses will be called and that the matter may be adjudicated on the joint minutes or affidavits to that effect. But I don't see that the court ordered in terms of Rule 38, Sub-Rule 2, that the matter can be decided on affidavits. Was such an application made?
I did not mention it on the judgment.
Yes. Thank you, TCJ.
Thank you very much, JP. Acting Premier, do you have questions for the candidate?
Oh, good morning, DCJ. I think I only have one question. It's related to cases of medical negligence.
All right, go ahead.
The only thing that I would want to hear from Mr. Masise, have you ever presided over such cases? And if yes, what are the lessons that you have learned from those cases, and what advice can you provide?
I've never presided in respect of medical negligences in these cases, except reading about them.
Also, you have never presided over such cases?
No, I've
And,
never.
yeah, because the judge president can attest to the matter that they have such cases. And I think it's a lot of cases, and such cases are costing this government a lot of money. These are the matters that you might want to look at. But the second question, which will be my last question, there's something funny that is happening in the Northwest Province. The majority of councillors here in the Northwest, on matters of intergovernmental relations, they prefer to take those issues to court. And the court, more often than not, must be seized with these matters almost on a daily basis. Do you have an advice as to what is it that we can do, or are there other mechanisms that can be applied to address issues of intergovernmental relations instead of us taking those issues to court?
Can I request that ask the Premier to repeat the last part? I did not get it quite clearly.
DCJ?
Is that
DCJ?
Commissioner yes, is it Commissioner Malema?
Yes.
Yes, how can you help
The
you,
acting
Commissioner?
premier of Northwest is really violating this meeting. He's putting this video with a political party emblem at the back. And he's doing this deliberate.
My goodness,
He's got a
I had
political
not even
party
looked
emblem
at
the
the
back.
screen.
Which means he has brought an ANC flag in a meeting of the JSC.
Okay, it's
This
sorted
is
out,
perfect.
Commissioner
Don't try
Malema.
that next time. You must respect this prince. He's not a branch of the ANC.
Can I request the Premier to...
My apologies, DCJ. I think we are correcting that. There is no need to fight over it, but
No,
we are correcting
we have a beautiful view of Lion's Head and a cloud overhead over Table Mountain and the sea. So we're happy with that.
Let's ask the minister if that view is better than the ANC flag.
Just repeat your second question, Acting Premier, please.
No, I was simply saying, are there mechanisms which Mr. Matsitse think we can consider to cap the use of the High Court to deal with matters of such nature, matters of intergovernmental relations?
Medical, there is something that I don't quite get it clearly, Premier, in that perhaps I'll ask DCJ if we have the question clearly, if you can just repeat it for me, perhaps because there is a lot of echo that I cannot hear properly in that regard.
Please repeat the question again, Acting Premier.
No, I can repeat that. Thanks very much, DCJ. I'm no longer on medical negligence. I think Mr. Matsitse did answer the question that he has never presided over such cases. My second case was related to councillors who are taking each other to court on a daily basis on matters of intergovernmental relations. So my question was, are there any mechanisms that you think we must think about to keep such use of High Court to deal with issues of intergovernmental relations? Thank you very much. I hope I was clear now, DCJ.
Okay, of councillors, if correctly, that they always take each other to court in that regard, shortly in that, if I understand it correctly. One can, like I said, I grew up in Northwest, and I won't say glued up in regard to traditional authorities, but however, I will say that one have to teach or try to go to the councillors and show them that it's not worth it to educate them what is supposed to happen and what is the correct thing that is supposed to happen in terms of the Traditional Authorities Act and what is required in that regard. I don't know whether I did answer the Premier.
This is
DCJ,
answer, Premier.
DCJ, I think let's leave it there. I'm okay.
Sorry?
He says
No, I
let's
was
leave
saying
it
it's
at
fine,
that.
DCJ. That was my last question. You can leave it there.
All right. I'll ask your last question then.
No, I'm saying that was my last question.
Oh.
We can leave it. We can leave it there. Yes.
Okay. Okay. Thank you, Acting Premier. Are there any questions for the candidates? Commissioner Narumahai?
Thank you very much, DCJ. Mula Remasiti.
Good afternoon, Prof.
Yes.
Councillor.
I have a question for you. Since we don't have a lot of judgments, perhaps, that came after your last interview, and we cannot really assess them to the extent to which we want to. But I just want to ask you a more substantive question with respect to the art of judging generally. Let's say you are presiding over a matter where there is a new set of attorneys who looked at a matter and they believe that it's a motion proceedings, and they believe that the notice of motion does not capture that which the client actually desires, and then they want to do something about it. One, in order for them to capture what they think their client needs, what should be done, what application can be brought with respect to that notice of motion. And if indeed there is an application that can be brought, what is the test that must be met in order for the client to be successful in changing the notice of motion, as it were?
They want to change the notice of motion.
Yes.
Okay. In terms of rule, they can bring the application in terms of Rule 28 to amend the notice of motion in that respect.
What is the test? Because it's not an application that you push and it's given. What will then be the test that the court will have to consider to see whether it is competent to grant such an order?
They number one, they will have to file the notice of intention to oppose. I mean, the notice of intention to amend. And when they filed, as long as it won't change.
Let me try to assist you. Now, let's say in their application, there's a founding affidavit. In the affidavit, what test do they need to satisfy you with for you to be able to grant, to make an order, whether to grant or to dismiss the application? What is the actual test that will guide you in whether or not the application is competent?
The test is that why they have to explain clearly why they did not state it during the normal affidavit originally when they filed, and the court will not just accept it in that they have to be sensing clearly, or they have to be more go too deeper in that respect.
I'm afraid not, but let me not take it further. Let me leave it there, DCJ.
Thank you, Commissioner Narumahai. Commissioner Steinberg?
Thank you, DCJ. Good afternoon.
Good afternoon,
Mr. Machitsi. I'm looking at your judgment in the application for leave to appeal in the Dance Sport South Africa matter, which starts on 108 of your questionnaire, of your application.
I've got it, Commissioner.
Would you go to page 110?
Yes, Commissioner.
So you cite the test for leave to appeal that is set out in section 17 of the Superior Courts Act. And at paragraph 6, you say the test laid down in section 17 of the Act is now a subjective one and no longer an objective test. Would you explain what you mean and why that's the case?
After reading several cases in that regard, that they made a ruling that it's after the amendment of section 17, objectively it was looking at what will other person or the reasonable person do. But more now, it's more straight that you have to make sure, or it has to be sure that there is a prospect of success in this. It's no longer a broad one, if I explain it that way. It's not a broad, but it's narrow interpretation in that regard, in the test, in order to prove to the court that you have the prospect of success.
So why is that now subjective instead of objective?
As I indicated, it's from the interpretation of other cases that, like the one that I've quoted of Van Heerden, that the test now it's more of a subjective than objective test.
Well, I think what that case points out is that the word should have a reasonable prospect of success is replaced with would have a reasonable prospect of success, as you point out. But the test remains objective, it's just stricter. Subjective would mean that the judge doesn't take objective test of reasonability into account, but is subjective about the subject. It doesn't speak to the difference between should and would. So it's unclear to me why you describe it as a subjective test.
I won't take it any further, but that's why I'm saying in that after reading several cases and following that one, that's why I went to that. I said it's more of a subjective than the objective one.
What do you understand the difference between an objective and a subjective test in law?
Subjective, it's more on a personal, or on a personal one. Objective, when you look at holistically other, I will use the word reasonable man, what will have happened in that regard. But subjective, it's more concerned with the person or yourself, a narrow interpretation in that regard.
Okay, thank you.
Thank you, Commissioner.
Commissioner Duff.
Oh, it's my turn. Thank you very much, DCJ. Good day, Magistrate.
Good day, Commissioner.
Yes. One of the major problems that this and concern that this commission had with your candidature in 2022 was about the grammatical errors that were picked up. Everybody picked these grammatical errors, legal bodies and so on. Now, if I put it to you now that, and I'm raising this question because during the deliberation, I will argue that your application and how you have crafted this application, including your judgments, are worse than in 2022. How will you respond to that? Because in this particular instance, you missed out all the necessary information that is required. This questionnaire, the first time when I came here, I thought perhaps that I didn't understand why all this information must be subjected to the candidates. But later I came to understand the rationale behind that. But now, with all this information that is missing, if I put it to you now that I'm going to argue that you are worse than the way you were in 2022, what will be your response to that? I want to afford you this opportunity to really share with the Commission that concern that I have.
Thank you, Commissioner. I won't say that it's worse, but I will say that I've put back the same, when I say same judgment or of the which were in 2022, and I wouldn't say that it hasn't changed that very much. I agree with you, but not being worse, but it's still this sort of on the same length as such. But I do understand your point in that, more particularly after what was raised by JP and DCJ with regard to the citizenship and the date of birth and others, that in that regard, I left it out when I did that. But I do understand what the Commissioner is saying.
No, it's okay. The last one, DCJ, I asked almost all the candidates who came here for the Northwest, and I'll ask you the same question. Northwest is 65% rural. Most of the disputes that are adjudicated by the High Court relates to the traditional authorities, councils, and so on, in terms of the Traditional Leadership and Governance Framework Act of 2003. Have you ever interacted with that legislation? And if yes, in what ways?
Have I ever interacted with?
Interacted or resolved a matter that pertains to the Traditional Leadership and Governance Framework Act of 2003?
I wouldn't say after 2003 I was here in Gauteng, but previously when I was in Northwest and when I was at the land court, not land court, the Department of Land Affairs, I interacted with the chiefs and the traditional authorities. So in that regard, whenever we were at their places, I was able to can advise and be able to assist them in that. But since when the act came into operation, I've not been in Northwest, but at home, I do assist wherever they say the chiefs or the headmen in my village will ask questions or ask guidance in that, but not formally in a formal way.
Thank you, DCJ.
Commissioner Mumeng.
Thank you, DCJ. Good day, Mr. Masite.
Good afternoon, Commissioner.
Thank you. I just have one question, which emanates from one Mr. Muntsiwa's letter in support of your candidature.
Yes, sir.
Yeah, there's a referral to, in his letter of support, that there was a need to appoint a Motswana male judge in the Northwest Division. The concern that I have, this letter of support, it's an undertone around tribal chauvinism and ethnicity, which run against the spirit of building a rainbow nation. Now the question to you is, what is your reaction to this? Because to me, it is a spoiler. I don't think such undertones in today's program of building a new nation. There is a space for such.
Commissioner, in the first place, I should say I did not even know Mr. Ramatlale. It just came, I was surprised when I saw it as such when it came in. But if I think he raised I don't know whether one will say the tone of his letters when we are trying to build a multiracial or in that regard. I wouldn't answer for him, but yes, it has to, one can interpret it as saying he wanted to bring to the attention of the commissioners or to the JC that we have Botswana and the area is a Botswana area, and one will understand the rules and the custom of that place. So yes, on the same breath is that it's sort of he is pushing for separation and he's not pushing for other nations that can come forward in that. But I cannot take it any further that for him, he can answer that. But yes, I might agree with you in that. But I'm just saying that he wanted to bring forward that perhaps demographics should be taken into consideration, the race in that area. And like in the say for argument's sake only in the constitution that the appointment of a person try to be suitable in that, but does not exclude a competent person if he's found to can be appointed, even if he's not Motswana.
Let me leave it there, DCJ. Thank you.
Thank you,
that was
Commissioner.
it.
Commissioner Muimang, do you have any questions for the candidates, commissioners on the virtual platform?
No, thank you.
Commissioner Malem? Commissioner Shabangundawe? Commissioner
This day I've
Pillay?
said no question from my side.
All right. Mr. I'm sorry, I struggle with this. Machize. Yes, pardon me.
DCJ.
We have reached the end of your interview, sir. Do you have any questions for us?
No, Commissioner, thank you.
Well,
No,
thank you for
DCJ,
making yourself
sorry.
available again. You're excused. Colleagues, I've just been informed by our secretariat that the next candidates are having their lunch and ours will be ready in 10 minutes. So I suggest that we adjourn now because we have no candidate to interview anyway, and convene here again after how long? How long do you want? 45 minutes. 45 minutes. Okay, that will take us to 1:45. Okay. Good afternoon, ma'am. How are you?
I'm well.
Right.
DCG.
I apologize for earlier. I know that when waiting to be interviewed is one of the,
It's
most
brutal.
yeah. So, um, you are coming here for the third time, applying for a vacancy in the Northwest High Court.
This is the second time I'm applying for Northwest.
You
The first time
were
it was-
interviewed in April 2021. For which vacancy was that?
It was Northwest DCG.
And in October 2022?
No, the first one, it was for KZN.
Oh, I see. So this is only your second time trying your luck at going back home as you pleaded with us last time.
I'm still pleading.
Okay. We should not be long with you because your CV is familiar to us. But just to remind ourselves, you are a holder of 3 degrees, Juris, LLB and LLM,
Yes, DCG.
obtained from the Northwest University and Nelson Mandela University.
Yes, DCG.
Your career has been centered in the Department of Justice, where you started as a clerk in 1989,
Yes, DCG.
and you worked your way through the ranks. You became a legal administration officer, prosecutor, magistrate, and finally a regional magistrate in 2004.
Yes, DCG.
And that's the position you still occupy.
That's where I'm still.
You have acted a number of times as a judge, that is.
Yes, DCG in KZN.
For how long?
The last time I was here, I haven't had any other stint since the last time I was here.
Oh.
The last time I was here, it was like 33 weeks, if I'm not mistaken.
And you do have written judgments.
Yes, DCG.
Yeah. And I saw that some of them were submitted to this body as late as last week.
Yes, the intention was to respond to a concern that I did not attach any of my High Court judgments.
Okay, we'll get to those. The professional bodies have, as you know, on both occasions noted concerns about your candidature, and those persist. And the General Counsel of the Bar, for example, laments, well, they say you have not been exposed to civil litigation. Although you are strong on criminal law, you lack in that area, and they set out where the areas of concern are. And there's a concern that you've hardly done any civil trials, you have not sat nearly enough in the motion court. Apparently, you have only 2 weeks' experience in that court.
No, in the High Court, I sat for a session doing motion court.
For how many times have you, how long have you sat in the motion court?
I think it was about 3 in that session.
How long are those?
The session, I think it was about 6 weeks.
Okay. So you were doing motions for
I was doing
for
only
6
motion,
weeks.
both opposed and unopposed.
And unopposed. All right. Well, there's also, well, the one complaint luckily has been dropped, which I thought was serious, where you're accused of absenting yourself from work and not not sitting in court through the day, both which were not substantiated.
I did not see that one.
No, they have dropped it. They say there was no substantiation for that for that accusation.
No, I did not even see, not in this time around. I did not see that. And I think it was maybe the first time or the second time. And if you want my response to that, I'll just say there's no truth to that. I have never been absent without leave.
No, well, what I'm trying to say actually is that you have been vindicated because no one has come forward to say to prove that you're actually guilty of that terrible conduct.
I understand.
Yeah. But there's still a concern about late judgments being delivered late.
No, it was that time. I don't have that problem. And I did indicate that time that I once had an issue with files in the regional court when we started civil work in the regional court about the misfiling and files going missing, which has fortunately improved quite a lot. We no longer have that.
All right. We have also been asked to find out if you have any health concerns because you have not completed that part of the questionnaire. Is there anything that you should bring to our attention in that regard?
I suffer from high blood pressure, for which I am on treatment. Other than that, nothing serious. From time to time, I do have this, I think the early onset of arthritis on one of my knees. Other than that, I'm healthy.
Those conditions do not hamper the performance of your work?
No, I do not believe so.
Yeah. All right. I'm going to hand over to Judge President Hendricks to put questions to you.
Thank you, DCJ. Good afternoon, Ms. Makwera.
Good afternoon, Judge.
How are you?
I'm doing well, thank you, sir. How are you?
I'm fine, thank you. Thanks for asking. Ms. Makwera, just for the record, I called you last year and I wanted to offer you an opportunity to come and act in the Northwest. You confirm that?
I confirm that, sir.
Yeah, and I asked you how many partnered matters did you have. You gave me a number, and when I spoke to the then acting regional court president, Andrews, she said, you have more than what you told me. You remember that?
No, may I correct you, sir?
Come again?
May I correct?
Yes.
When we spoke, you didn't ask me about the number of partheads at all. You didn't ask me about the number of partheads. You just asked me, would I be interested? Can I avail myself? I said yes.
No. If my memory serves me well, I even called you a second time. I don't want to belabor this point, to inform you that that is what acting regional court president Andrews told me. You remember that?
Can I correct? I maintain what I'm saying. When you called me, you asked me, you told me you want to offer me a chance to come and act. I said, I would be very grateful. And then you said, it will be around June. Will I be available? I said yes. And then I said, could you kindly inform the regional court president? You asked me for her number. I did not have it. I said, I will call and thereafter I'll give you the number. Then I gave you the number, you called her.
No.
And then the issue of partheads, after you called me, I called her to tell her that you asked for her number. And I even told her what you'll be calling her about. And I told her, and this is my position as far as my court work is concerned, I have so many partheads. But I have agreed to avail myself because I was told the acting stint will be in June, and that time it was February. So I'm the one who even brought the number of parties to her attention, and she said, okay, I'll wait for his call. Then when you called me, you told me she told you that I have that number of parties, which I confirmed, and I told you that no, my plan was to work through the parties until June. That is what happened, how I remember it happening.
Yeah,
I did
my
not
re-
misrepresent the
my-
number of parties that I had.
My recollection differs, but it's fine. Let's go to your application. As far as legal background is concerned, it's stated that you mainly did criminal work.
Yes.
And you last acted in the High Court in 2021. Is that correct?
I think I'm not sure. It could be 21 or 22. I'm not really sure.
Yeah. Now, in 9.3, you stated that in 2021, and I quote, in 2021, I did motion court. How many motion courts did you do?
As in sitting in court, it was about 3 doing unopposed motion. But there were times when I would go for, I did 3 opposed motion.
And unopposed?
Unopposed, I would do an average of about 40 files.
Do you have any parted matters?
As we speak, I have 8 parted matters.
8 parted matters.
8. May I explain something about parties, please, JP? The regional court is not like the High Court, I'm sure, or just maybe for the benefit of those who are not aware. It is extremely difficult to start a case and finish it within a week. There are so many problems. The first one is the workload. There's a lot of work in the regional court. Some of the cases that we do, sometimes I feel are cases which could have been taken to the High Court, but they come to the regional court. Of late, there are cases that are supposed, rightly, I believe, that could be done in the district court, but they end up in the regional court. So our workload is, we get an average of 20 new per trial, 20 new matters per month. So it's, unless you just want to finish the cases for the sake of finishing them, so that when you come here, you should appear like somebody who is up to speed because it doesn't have parties. You can do that, but at the end of the day, we want to see justice being done. That's why we have parties, and I'm sure in recognition of this fact, our practice directive says a regional magistrate can have about 15 parties at a time, not exceeding 15.
Okay, thank you. In paragraph 9.6, you listed 5 matters, which was partly at that stage when you applied. How many of these did you finalize? And how many are still outstanding?
I have finalized 3 of these ones, but there are others that I have since started after submitting this questioning.
Yes. Do you do civil work in the regional court?
I have been doing civil work from the time when the regional court were given civil jurisdiction. And initially, I was the only one doing it. That would be from around 2012. It is only recently, around 2020, when other colleagues showed interest in civil work, that I went back to the to the criminal court, but I have since gone back again to the civil court.
Yeah. What is the workload as far as civil work is concerned in the regional court?
We have a lot of applications. almost every day. On the day, we do our applications on Thursday. So Mondays, about 3 days in a week is for trials. Most of the trials, they end up not proceeding for one reason or another. Then we do divorces. Divorces, we do average of 30 unopposed 30 divorces per week. The one thing that really keeps us busy is divorces and applications. Trials, the numbers are not that high.
Yes. As far as administrative law is concerned, you indicated that you did not do much cases involving administrative law.
Yes, but when I was acting in the High Court, I had occasion to do one application, a PAJA application. Unfortunately, when I sent the cases that I sent last week, it was among those, but for some reason it was not transmitted until around Sunday. I got information that it did not come through because I had to check what cases were received by JSC, and I was told that only 3 were received. I had sent 5, and this PAJA application happens to be among the one that was not transmitted, but I do have a copy of the judgment.
Yes. You also indicated that as far as constitutional law is concerned, almost all matters, if not all, have elements of constitutional law. What do you mean by that?
I mean, if I'm sitting in a criminal court and an issue arises, I have to apply the Constitution. Because the Constitution is like the lens through which we have to do everything that we do. When I'm explaining the right to legal representation, it's Section 35. So we invoke not only in criminal work, even in civil work. When you are dealing with, say, a PI application, you are talking about eviction is the right to housing.
Yes. In the Northwest, between 80 and 90% of the work is civil work and not criminal work in the High Court. Are you aware of this?
I have heard, because I had to inquire from someone who's working there.
Okay. Thank you, DCJ.
Thank you, JP. Acting Premier, do you have questions for this candidate?
No, thanks, DCJ. I think I just have a few questions. And good afternoon, Ms. Mokwera. DCJ, am I audible enough?
Yeah, we can hear you.
Oh, no, okay, no, thank you very much. Ms. Mokwera, just remind me quickly. Did you say, have you acted in the Northwest High Court before or not?
No, I have never acted in Northwest, Commissioner.
Okay, and have you familiarized yourself with the workings of the Northwest High Court?
I've been asking around because I had interest.
Okay. And from where you are sitting, do you think are there challenges in that court?
The last time, the only challenge I heard about, I was told that there was a backlog with criminal matters. That's all. That's the last thing I heard. That I'm not really. I was just interested to know what kind of work, if I do get a chance to act there, what I can expect.
Okay. And then let's quickly talk about representativity. Do you think do we have enough women and people of other races in that court?
Women, the last time I checked, it was the DJP. There is also a white lady, I think, and there was also an Indian lady. I think she has since retired, Judge Gata, if I'm not mistaken. So for now, I think there are two ladies, if I'm not mistaken.
Okay.
And
And then-
about three or four men, I'm not sure.
Okay. Okay, and then tell me one thing quickly, because in the Northwest, you will agree that there are issues of traditional leadership and so on. Are you familiar with the Traditional and Quaysand Leadership Act?
Not that much. All I know about traditional leadership is that there was a bill, I think it was traditional courts, the bill that came out in 2008 that never saw the light of day. I'm talking about traditional courts. And then there is it was withdrawn, and one came out again in 2012 and then 2017. But I'm aware that that Constitution, Section 211 of the Constitution, provides that constitutional customary law is a law that is it is a system of law that is akin. It should be given recognition in other ways, the same recognition as common law, and that the courts should apply it where it is applicable. It's subject to the Constitution and the legislation that pertains to customary law.
No, DCJ, my last question was related to the same act, because I had wanted to raise a question about the implementability of Section 59 of that act, but I think Memo Khwera has not as yet familiarized herself with that act. I think I must just leave that one for now. And then the last question, which I hope it will not be controversial. In your opinion, Ms. Mokwera, do you think Section 47, subsection 1E of the Constitution, that deals with convictions of offenses and sentences to a maximum of 24 months imprisonment, do you think contradicts Section 84, subsection 2J, which deals with pardoning, reprieve, and remittance of any fines? Do you think there are contradictions between the two sections, Section 47 and Section 84?
Perhaps if you can just remind me what the Section 47 provides.
Section 47 deals with conviction of an offense and sentence to more than 12 months imprisonment.
Yes.
That's 47. 84-2J, it deals with pardoning, reprieve, and remittance of any sentence. Do you think there are contradictions between these two sections?
It's difficult for me to answer that. I maybe if you could shed more light, contradictions in what sense I can't follow.
No, that's what I'm asking you. Do you think there are contradictions between the two sections? But if it is a bit difficult, we can leave it. DCJ, that was my last question.
Thank you, Acting Premier. Do you have questions for the candidate, colleagues? Commissioner Marumakhai?
Thank you very much, DCJ. Dumela Mme Mokwera. I have a question. I just want us to deal with a sort of a substantive but procedural sort of question in any event. Sometimes, you know, litigants are easy to accuse judges of not having the innate ability to accept when they are wrong. And I'm not talking about you, I'm just saying generally, I'm not talking about you. And sometimes this is demonstrated when they go to, when the judge has made an order and they go to the same judge and say, but you are wrong. We want another court to look at what you did. Perhaps maybe that court can come to a different a decision. Based on that, I just want to ask you, when one deals with applications for leave to appeal, obviously what I've just said is not a test. What is it that the court that is seized with that matter, that has made a decision, will come to a conclusion that perhaps maybe another court might do, in other words, allowing the litigant to go to another court? What is like the test that can allow the matter to go to another court?
Thank you for that question, Professor Marumahai. I'll try and answer it this way. We all, that is why the beauty of our system is the appellate powers, this appellate jurisdiction of superior courts. Obviously, when an application like that is brought to you, you need to divorce yourself from your initial thinking about the matter and try and see it from the point of view of the person who's bringing the application before you, and to apply your mind as if you are an outsider, not the person who made the decision. And depending, of course, on the argument that is brought to you pertaining to the merits of the case, then decide if you are convinced that another person, when he looks at this decision, could come to a different finding. It is the only way that you can. But if you are stuck to, I believe that you are guilty in a criminal court, I believe you are guilty and nothing can change my mind. It's not about what you are thinking. It's about what another person, given the same facts.
I was more looking at what the rules actually provide and how the courts have shaped the actual test. But we don't have to take it further. I will accept your question. Thank you very much, DCJ.
Commissioner Nyambe.
Thank you, DCJ. Afternoon.
Afternoon, Commissioner.
Have you seen the comments by the law bodies, all of them?
Yes, I have.
I have just one question. The last time we were here, even though it has been some time, anything that is significant that this time around we have to seriously consider that might have made you to be at a better position than then, that we have to look at now?
When I availed myself after I had been nominated, I also thought about that, because the complaint is not even a complaint or criticism from the law bodies, it's a concern. And I don't have any problem with the concern. As far as I'm concerned, it is legitimate concern. I'm sure I would have that same concern if I were in their position. But I want to explain this way. When I availed myself to come before to submit my name again for reconsideration, I deliberately submitted only my regional court judgments, civil judgments, with the view that because I've been before this commission before and because this concern has been raised before, I do not even stand a chance. They will look at this and say nothing has changed as far as the civil work in the High Court is concerned. And I told myself, if they consider this something that is worth giving me a chance, that is worth considering for the purpose of giving me a chance, then I take it that they believe that there is something in me, there's some potential in me to be able to stand for this position. I have not been to the High Court since that time, like I say. Of course, it depends on invitation, and you make yourself available. if you are not invited, you don't stand a chance of accumulating experience. But, and I want to reiterate this, having worked in the High Court, that one stint doing motion court, I got the confidence that I could do this because I coped very well. The rules are the same, almost identical, and I could handle that in the High Court. I could handle the motion court like I do in the regional court. I could engage with counsel if I don't understand anything, and I even wrote judgments that in motion court judgments. So I can't say a lot has changed as such, but I can only offer what I have. What I cannot have experience in the High Court if I don't get a chance to sit in the High Court and gain that experience. But I'm confident that I can handle work that will be given to me. And I'm prepared. Can I also say that for anything that I lack in terms of civil experience in the High Court, because I'm a type of person who doesn't like to be the weakest link, I'm prepared. I'm naturally a hard worker. I'm prepared to work even harder than, so that I bring myself up to speed and I don't become the weakest link. I don't know if that answers you, Commissioner.
It does. The last one, the last time you were here, I'm happy you said nothing much has changed. The last time you were here, Prof. Marumo Khai and Advocate Nkukaito engaged you about your judgment. And Commissioner Magwanish dealt with the issue of starting court late that was coming from Advocate for Transformation. I got the same sense when you're dealing with the JP about the issue of the calls, how you dealt with them, that indeed there's nothing much that has changed. So I invite you to comment about that so that I can be fair to you when we have our own closed session for deliberations. Because when you engage the JP now about the calls, I was more confused. I don't know who's telling us the correct version of what happened in that call. But I remember the last time we were here about the issue of starting court late and how you adjourned, and it was coming from the law bodies. And I got the same sense even today. That is why I ask about what has changed.
Thank you, Commissioner. I maintain, I remember very well what happened when I engaged with the JP. The JP phoned me, he was in...
You've already given us your version.
Yes, I
we
maintain
don't want
that...
to be bogged down in a dispute of fact.
Okay,
Yeah.
thank you, DCJ. What I say is how I remember things happening. The engagement, the last engagement with Professor Marumagai and Advocate Ngukaitobi, I agree that the way I had handled the case that they were complaining about is not how I could have done better in that case. I accept. And we all err. That was an error on my part, and we learn from errors. It's not that I want to be argumentative, Commissioner, because I get the impression that you are implying that I'm argumentative. I will not concede to something that did not happen the way I know it. And I have interest in that matter. That is why I can say with certainty how the whole issue unfolded.
Thank you, DCJ.
Yeah. Commissioner Singh?
Thank you very much, DCJ. It's a very short one. Good afternoon.
Good afternoon.
Born in the Northwest, started off in Port Elizabeth, then Durban. Now you want to go back to the Northwest. I think KZN seems to be your home now, your adopted home. You've applied for a post in KZN before. Are you aware of any vacancies that may come up in KZN, or have you applied for any vacancies since you last came before us?
Not really. Since I was here, I applied once. I was not shortlisted. In
Are you-
fact, it was the time when I had applied for both Northwest and KZN. I was not shortlisted for KZN. I was shortlisted for Northwest. And since that time, I have not applied again because, as I indicated last time when I was here, I would really, really want to go back home to the Northwest, back to my home.
So that's the reason that's driving you. And there are vacancies that have come up in KZN that you
I
may.
think there was, after that shortlisting, there was only one for which I did not apply.
Thank you. Thank you.
Any further questions for the candidate, Commissioner Dodov?
Thank you very much, DCJ. Just good afternoon, Magistrate Mohuera.
Good afternoon, Commissioner.
Most of the questions were asked by commissioners, including the acting Premier of the Northwest. I will not repeat those questions. But there remain a concern for me. As I listen to the JP of the Northwest, many cases that are handled in his division pertains to civil cases more than criminal cases, and I can see that you have a very strong background on criminal cases. And just now, you've just considered about the matter that was raised by Advocate Ngaitobi and Professor, yes, that you accept wholeheartedly the mistake. And then again, listening to what the JP was saying in respect of the fact that he was willing to integrate you, to give you the opportunity to act, and you were willing to act. Don't you think that you need more time to, I'm just asking because there's a matter that is in my head. Don't you think that you need more time to act so that you get exposure in respect of the civil matter, so that for the implication of the future perspective, you are okay, you are better off in that respect? Don't you think that could be the best way forward? Thank you.
I could never say, thank you, Commissioner. I could never say no to being given a chance to act. In fact, that's something that I have been praying for. However, having said that, I would really want to urge this commission to judge my competence in the civil work from the work that I have submitted to you. If maybe because I've submitted, I think, a judgment, one civil judgment, I have submitted even a civil appeal that I had the opportunity to scribe. I have submitted an application judgment, and judge from there if, despite my lack of a long exposure in the civil court at high court level, I do not understand how to write a judgment. I do not have knowledge of the law to analyze the evidence, all the things that are required in a judicial officer when he's writing a judgment. If you feel that I am lacking, then I would concede that I am not there yet. But I believe that I can handle the work.
Okay, I was just asking that question. Thank you very much, DCJ.
Could I ask for a follow-up to this point?
Yes, Commissioner Goito.
Yes, Judge, so yes, you've been saying to us, no, we should consider you for civil practice, and you've now accumulated enough experience, and that it may have been okay on the last occasion not to accept you based on lack of experience. That's my understanding broadly of your thesis today.
Yes.
Yes. Now, I just want to ask you one or two civil procedure questions on things that emerge daily in the civil courts. All right, it's not an exam, but it's just to get a practical sense of the extent of your knowledge. So an application is brought as a motion, and a dispute of fact arises, in your opinion, that is not resolvable on the facts. And there is a High Court rule, which is 65G. What are the three options that that rule permits to the judge?
You may decide the application on the facts that are not disputed.
No. You have decided. That's why I'm saying 65G is not for that. That's Plascon Evans. It is where you cannot decide the case because there is an irresolvable dispute of fact. And then you have three options under Rule 65G. What are those options and how do they differ?
You may refer the case to oral evidence if the disputes are of a narrow nature.
And what should you do when you refer it to oral evidence under that rule?
It's just that I would have preferred if you gave me because we are talking about High Court rules. I'm used to but they are similar.
But no,
But
I mean, you want
dis-
a job in the High Court. That's why I'm asking you about the High Court.
Yeah, you decide if the issues that are in dispute are narrow. If those issues are narrow, they do not require that the case we refer to for trial, you refer it for oral evidence. I don't know if I'm answering you. And then if the issues are very broad, then you may refer the case for trial. And the affidavits that have been submitted, they act as your pleadings in a case like that. You can even invite the parties to file supplementary affidavits.
Yes.
Do you want me to continue?
Yes, and that's what I asked for. It's an open question.
Or the case may be dismissed. You can dismiss the application outright because, especially where the dispute was foreseeable, it's something that the applicant should have anticipated will happen.
Yes. And what are the conditions when you are referring the matter to oral evidence? And how does that differ to referring the matter to trial?
When you are referring it for oral evidence, they only have to deal with that specific aspect.
Yes, but what should the judge do? So you are now judging, and you think, well, I must now choose trial, oral evidence. What should you do under the rule?
I think the determining factor is the nature of the dispute itself.
Yes,
And
but once you've decided it's oral evidence, what should you do under that rule?
maybe something that I haven't really thought of.
Thank you, TCJ.
Oopsie. Are there questions from the virtual platform? No.
No, thank you, PCJ.
Thank you. Do you have any questions for us, Ms. Mohuere? We've run out from our end.
Perhaps just to reiterate what I said to DCJ, that I would really appreciate if you judge me on what I have placed before you. Of course, some things, when you have to do something, you have to go and research. As long as you know where to find the law, you can never go wrong. I'm the type of person also who is not afraid to approach and ask for advice where I'm not sure. That is all I would like to bring to the attention of
We've
the
heard
commission,
you.
and also to thank you for the opportunity for inviting me once more. And I hope that things will go well. I thank you so much.
Okay. Well, thanks to you too for making yourself available. And let's see how it goes. You have two competitors, so
Thank you.
yeah. Thank you, Ms. Mkhwara, you're excused. Good afternoon, Magistrate Reddy.
Good afternoon, Deputy Chief Justice.
How are you?
Well, thanks, and I hope the position is the same with yourself and all of the commissioners.
I think it is. Yeah. You are a regional magistrate here in Johannesburg.
That is correct, Deputy Chief Justice.
Mhm. And your foray in the legal field started with you obtaining a B.Juris degree in 1991. Then you went on to acquire an LLB in 1998. And finally, a master's degree in law in 2003.
That's correct, Deputy Chief Justice.
Oh, but then you subsequently did a diploma in criminal justice and forensic investigation in 2007.
That's correct, Deputy Chief Justice.
And I'm just looking at the timeline of your career progression. You were acting as a regional court magistrate at the time, so you wanted to really hone your skill in the field of criminal law.
That is correct, Deputy Chief Justice.
You started out as a prosecutor in KZN?
That's correct, Deputy Chief Justice.
Is that when you were studying for your B.Juris, or have you already obtained it?
My B.Juris had already been conferred on me,
Mm.
and I had already started my prosecutorial career before embarking on my LLB.
Yes. So you furthered your studies part-time while you were working?
That's correct, Deputy Chief Justice, and that was the position for the LLM as well as the diploma.
Yes, I admire that. Can't be an easy thing to do. So you rose through the ranks, became a senior prosecutor in the magistrates court, then you went up to the regional court, and finally joined the magistracy, made your way up there to all the way up to the regional court.
That is correct, Deputy Chief Justice.
So how does this career, how long does it span? Career as a magistrate, it starts in 1996, 27 years.
That is correct. It started on the 1st of November 1996 up until present.
Almost 28 years. All right. You have acted as a judge in this court to which you are applying since October 2022.
That is correct, Deputy Chief Justice.
How long have you acted? How long did you act there? I take it you're no longer there now.
Yes, that's correct. In total, it's 64 weeks.
What kind of work did you do during that period?
I would say predominantly it was civil work and a small percentage of criminal, and I think probably 1% of contract and some administrative law.
But you did have experience in the civil court from the magistracy, not so?
That is correct. As a district court magistrate, I had some civil experience, but for the last 10 years, I've been sitting purely in the civil regional court in Johannesburg.
Have you written judgments as a magistrate?
That is correct, Deputy Chief Justice.
How many? An estimate would do.
It probably go into the hundreds if I have to combine the district as well as the regional court.
That's commendable. In my experience, magistrates hardly write judgments. They would be proud to advertise because of the pressures of and the poor conditions in that part of the judiciary. And you've written in the High Court as well.
That is correct, Deputy Chief Justice.
How many there?
The total of my judgments would be 86. 4 of them would be extempore, and 2 judgments I co-penned with one of the senior judges, which went out as the court, but my own individual judgments would be 80. 34 of those were unopposed, or correction, opposed motions. 10 were civil trials. 8 were urgent matters. 13 were full bench appeals. 3 were full court appeals. 6 were reviews. 4 criminal matters, and 2 leave to appeals.
I see that you were, one of the cases in which you were involved is the Marikana miners case. What role did you play there?
That was a special criminal trial that was allocated to me, Deputy Chief Justice. I was seized with running the trial for a week, but the trial turned out into a prolonged application for postponement, which then I had to rule on. And the argument went on for the Tuesday and the Wednesday. I penned the judgment on the Thursday, and I handed it down on the Friday.
Speedy justice. All right. Well, the law bodies speak highly of your prowess. You seem to have impressed everyone all around.
I don't really think it's a prowess. I think it's a work in the making, but I accept those compliments.
Right. All right. I'll leave it here for now and ask JP Hendricks to put questions to you if he has any. JP?
Thank you, DCJ. Good afternoon, Mr. Reddy.
Good afternoon, JP.
You have been acting in the Northwest for a considerable period of time. What is your experience as far as the workload in that division is concerned?
I think that if I had to sum it up, I would have to say the harvest is great, but the workers are few. There is a lot of civil work that needs to be done, and it requires you to work extended hours, and it requires you to be efficient and to be skilled in multiple different kinds of legal work.
And if you must estimate, as far as percentages is concerned, what is the percentage of civil work vis-a-vis criminal work in the division?
In my own experience, I have been allocated, or I would estimate that the percentage of my civil work would have been 90%, vis-a-vis my criminal work would probably be about 5%.
Do you have come across any cases in administrative law?
Yes, I have penned, I think, 2 or 3 judgments dealing with administrative law.
Concerning municipalities?
That is correct.
The time frame for handing down judgments, there is the norms and standards as well as the Judicial Code of Conduct. Have you complied with it?
I would have to say that there has been compliance, but I put my hand up and say there are instances, in fact, where I have exceeded the timelines. But in those instances, I have always brought it to the attention of the Judge President. And at the end of each term, I presented a report as far as what work that I had been allocated and how I had performed. In addition to that, where I had transgressed on timelines, I applied for an extension of time and attached the draft judgments that were work in progress to indicate where I was as far as my draft judgments were concerned. And I would also indicate what were my challenges as far as the non-compliance with timeframes.
Yes. Have any of your judgments been reported? And if so, where?
On the Safely Northwest website, I think 80% of my judgments have been reported. And I'm given to understand that some of the judgments were reported on JOL, LexisNexis, and I've also noticed that some of them have been on Legal Brief, but purely in the South African criminal reports and the South African law reports, none of those.
Yes. Thank you, DCJ.
And just before I invite the acting premier to put questions to you, I want to highlight important work that I overlooked when I talked to you earlier. You have been a commissioner in the Small Claims Court since 2014.
That is correct.
And you continue to work there to date?
No, Deputy Chief Justice.
Well, that's what your questionnaire says.
I'm still a commissioner of the Small Claims Court, but given my acting stints in the Northwest High Court, I wasn't able to completely give attention to the Small Claims Court because the Small Claims Court is generally held on Tuesdays, Wednesdays, and Thursdays at the Soweto Magistrates Court. And I should just add that is generally after 4 o'clock. It actually commences at 1700 hours.
All right. Thank you. Acting Premier, do you have questions for this candidate?
I'm about to shock myself and my colleagues on the platform. I have no questions.
Commissioner Singh?
Thank you very much, DCG. Good afternoon. Mr. Reddy.
Good afternoon,
Sorry about
Commissioner.
that. Thank you. Yeah, I see you've acted for a long time in the Northwest. Were you ever invited or did you make any advances to ask for acting positions in Gauteng since you are based in Gauteng?
I must reply by saying I'm a stickler for the rules. I was given to understand that there's a certain protocol that needs to be followed before you identified as an acting judge. In saying that, I was identified as a potential acting judge in 2012. I attended the advanced judges training in 2013. And between the hiatus of 2013 and I think September 2022, I was not invited to act. My regional court president said that I should, via his office, write a letter in order to indicate my willingness to act, which I did. And I didn't hear anything from that. And so I let things be until I had an invite from the Gauteng High Court in 2022. Unfortunately, due to personal circumstances, I could not accept that invite for the 2 weeks. And subsequently, I was invited to the Northwest. And as they say, the rest is history.
So you were invited by Gauteng, but circumstances didn't allow you to.
I was invited for 2 weeks, yes, in 2022.
Okay. My last question would be, some of your judgments went over the prescribed time and you said there were particular challenges. Would you like to just share some of those challenges?
I think it's more to do with time management, and it's more to do with the quantity of work. The Northwest is not I must prefix it by saying that I've only acted in the Northwest, so I cannot speak for other divisions. But the Northwest is not an easy division. It requires, and I'm sure that's the position in other divisions, it requires of you it's a 14 to 15 hour day. For example, when you're doing motion court, there's no reading day. You'll get the motions on Tuesday, which is over 100, until the judge president has now limited it to 100. So there's no reading day. You'll get the motions on Tuesday at 12 o'clock. Remember, you're in court on Tuesday. You're in court on Wednesday. So there's no room to have the luxury of sleep. You've got to work on Tuesday. You've got to work on Wednesday. You've got to do the motions on Thursday. After the motion court, you are still allocated with opposed motions. And Friday, generally, you are in appeals. Apart from your motions, if you're doing motions, you are the urgent court judge. And I think also probably my writing style, and with the passage of time, you'll probably to shorten the judgments. Because if you look at some of the judgments, most of them, I think, are in excess of 50 or 60 paragraphs. So it's a process of chopping and changing, rearranging. But as I indicated earlier, I've always brought my judgments under the attention of the judge president or the deputy judge president where I was out of time. And in instances, I even wrote to the parties via the registrar to indicate that the judgment is probably due in 3 months, or this is the day, these are the challenges, and when they may anticipate the handing down of same.
Thank you very much, Mr. Reddy. Thank you, DCJ.
So, Commissioner Nyambi, someone raised their hand over there? Yeah, it was you.
Well, thank you very much. This is Jay once more. Good afternoon. Magistrate ready?
Good afternoon, Commissioner.
Okay. I like asking this question relating to the traditional leadership and the disputes which arise. I used to be the MEC for traditional affairs in that province, and I feel very strong about this because I know what happened in the past. Have you handled any matter pertaining to traditional disputes in the Northwest, whether it's urgent matter or as a trial?
Indeed so, Commissioner. I've handled two matters, one of which was disposed of on a point in limine, and the second was to deal with the regulations that were promulgated by the MEC regarding the Khoisan Act. And I think the Judge President has attempted to hone my skills in that area by allocating me a special motion in the last term, which deals with the complexities of traditional leadership.
Which means you are familiar with the Traditional Leadership and Governance Framework Act of 2003. You said yes.
I would say that I'm scratching the surface of the legislation, but I think after this judgment that is penned, it will probably give me a more in-depth understanding of the legislation.
All right. Thank you very much. The last question. You saying that you have adjudicated matters, administrative law matters pertaining to municipalities, were they in relation to the invocation of or disputes around the invocation of Section 139 of the Constitution or what?
It didn't hone particularly on that, but that had come up in a matter, actually in a defamation matter, where, and I don't think I'm at liberty to mention the name of the plaintiff, as it in fact involves a high-profile individual. But be that as it may, Section 139 did come up there, dealing with Section 100 and what would the national government's view as far as Section 100 is concerned, how the provincial government would probably apply Section 139, and relating to the interplay between national, provincial, and municipal government.
No, thank you very much. In the interest of the fact that I might be conflicted, because I was the chairperson of the ad hoc committee that was dealing with Section 100 in the Northwest Province, I will not take this particular matter further. Thank you very much, DCJ.
All right. Prof. Bormochai, did you have a follow-up question?
No, not the follow-up.
Oh, okay. Then it's Commissioner Nyambi.
Thanks, DCJ. Afternoon, Magistrate Ready.
Good afternoon, Commissioner.
One question from my side. It's very rare to have law bodies commending the good role that we are playing in that part of our beautiful country. My question is, if you can share with us the attributes of a good judge and probably focus on three, probably focus on those that you think you have.
If I can just prefix it and say that my performance in the High Court is not unique. If you have to page through, and I'm certain you have, as far as my experience is concerned, it's 3 decades, and my performance has been consistent since the 1st of July 1991. So I have consistently performed since the embryo of my career. And I accept what the law bodies say. But an examination of my career will indicate that my performance has been consistent throughout. As far as qualities that embody a good judge, I think there's a plethora of qualities, but I think in the final analysis it would come to impartiality, integrity, and fairness.
So you do have the three?
Regrettably, yes.
No, thank you, Magistrate Reddy. Thank you, DCJ.
Prof.
Thank you very much, DCJ. Good afternoon, Judge Reddy.
Good afternoon, Commissioner.
Yes. Can I please take you to? Oh, by the way, I concur with the law bodies. I have the same view as what they have expressed about your work. Can I please take you to page 90 of your questionnaire or the bundle that you submitted? Or let me save you the time. You gave us the list of judgments that you authored, and in number 32, there is a judgment there. There is no copy of the judgment here, but nonetheless, you submitted here. And when I was preparing, I got interested in it in particular. I won't bore you with the details, but I'm just concerned with the substance of it. In fact, I need to say this. It seems to me that insolvency law is becoming a problem in our courts generally, and something that is extremely concerning. In this judgment, you remember it. It's RDM versus MTM. It was delivered on the 21st of November 2023. These were married people out of community of property. The other one was sequestrating the other one. Do you remember it?
It doesn't ring a bell.
Doesn't ring a
and
bell.
I'm not too sure if it is in fact my judgment. Is it perhaps to do, if I have to inquire, is it perhaps to do with an accrual?
Yes, with the accrual. I got it from your questionnaire, so it would be surprising if it was not yours.
No, I'm with you.
Oh, yes. It seems to me that the judgment was about sequestrating, one spouse sequestrating the estate of the other. In the judgment, you deal with provisional sequestration, Section 9 of the Insolvency Act. And then you deal with, Section 10 of the Insolvency Act. And then you deal with Section 9 and other provisions. Because you don't have the judgment, it will be unfair for me to refer to the specifics. I want to ask you a direct question, perhaps, that we can deal with. When insolvency or sequestration is brought in terms of Section 8, and one or more of the 8 subsections of that section, those acts of insolvency, if you find that there is no act of insolvency that has been, let's forget about provisional sequestration, because now once you are dealing with that Section 8, that means you are on the realm of sequestration itself, and we are going to the final lane. Right? When you find that there is no act of insolvency that has been found to have been established, is there a need to deal with the actual requirement of compulsory sequestration? Because the act of insolvency is one thing, and Section 9 and Section 12, which gives you the actual requirements of compulsory sequestration, is another thing. So what I've seen in the courts general and in this judgment, it seems like Section 8 is just one of the requirements that are put. Is there a need, or is it a two sort of leg system?
I would have to say that the matter from the SA just escapes me now. But the principle is that if you are seized with the matter, you shouldn't actually deal with it in piecemeal. You should be able to deal with all the factors that are placed before you to ensure that you have a complete judgment. But I'm with you when you say that if there is no act of insolvency, that should be dispositive of the matter.
Yes, and this is a concern. It's probably not to you generally, and the thing is that's something that has been bothering me when I read judgments, because it seems to me that, because remember you're going to deal with the provisional sequestration, and if you pass that stage, then the return date. On the return date, that's when you deal with the actual thing. And I'm talking about when we are at the return date, right? That it seems to me that judges, and there is another judgment from that court, which is extremely concerning, but that judge is not here, so we cannot deal with that. Where it seems to me that there is a serious confusion as to what needs to be done first, and if that thing is not done, whether we go into the requirements. And I think that is where I have some challenge, but I will accept what you're saying.
Thank you.
Thank you very much, DCJ.
Commissioner Klopp?
Thank you, DCJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Thank you. Thank you. I see that on your CV, you give us your address as Durban,
That's
and
the
you
plan.
apply for a position in the Northwest. And you have you had an acting stint in the Northwest. Was it because the acting stints were not available in KwaZulu-Natal?
Just a point of correction. My place of birth is Durban. As I indicated, for the last 10 years and presently, I'm a regional magistrate at the Johannesburg Civil Regional Court. So my official, for want of legal phraseology, domicilium would be Johannesburg. How I ended up in the Northwest, as I earlier indicated, I'm a stickler for the rules. I followed protocol and I received an invite. And after getting the blessings of my regional court president of Gauteng, I accepted the invite.
I'm told that it's hot in Northwest. Do you think you'll cope?
It's a struggle, but I'm capable of adapting.
Thank you.
Commissioner Ngqetho?
Yes, thank you, Deputy Chief Justice. Magistrate Reddy, I have two questions. One is procedural, the other is substantive. Now let's start with the procedural one, which I asked the last candidate. I'm not sure if you had and prepared yourself on. If you a judge in motion court and an application was brought for a final order, and when you read the papers, there is a dispute of fact which cannot be resolved on the papers. There is a rule that guides you, which is Rule 65G, and it gives you three alternatives that you can apply in those circumstances. What are they and how do they differ?
I think the first one is you will dismiss the application. The second one is that
Not you will, you may dismiss the application. Anyway.
I should have firstly said good afternoon. My apologies. You can dismiss the application. You can refer it to oral evidence, or you can refer it to trial.
Yes, but how do they differ, specifically the second and the third?
When you refer to oral evidence, I think you're going to specify what the specific dispute that needs to be adjudicated in terms of the application.
And then? There's something else you must do under that rule. Firstly, you have to specify the issues, then there's something else.
I must be honest, I've drawn a blank there.
Okay, no, that's fine. And then trial,
Trial will be the hearing of evidence, and at the conclusion of the hearing of evidence will then be a determination as to whether you find for the applicant or for the respondent.
no, but we still have this situation where it sounds like oral evidence and trial are the same thing. And what I'm trying to draw is your understanding that when you are referring a matter to trial and when you are referring to oral evidence, there is a difference.
The reference to oral evidence will be on a specific issue.
Yes.
And the reference to trial will be probably on the conspectus of the application.
All right, okay, that's good enough. I can live with that. Then let's look at the substantive question. I have 2.1 and 2.2. 2.1, there is a mining company. It's a theoretical mining company. It has a mining right. It needs access to communal land. It is entitled to access to the land under Section 5 of the MPRDA if it can identify the owner. But the community does not have a written title over the land. And the mine wishes to evict the community. Which law applies? And the community lives under customary law. Which law applies? And what is the case that you can think of? And I'll give you the name of the scribe of the case. It's Spetzer AJ.
It seems you have a knack of stumping me, but just give me a moment.
Well, just give me the principles. Forget about the name of the case. I can give you the case. It's Maledu. But because that's not an exam, but give me the principles. I want to understand that substantively you know the law in that area.
I will have to say that you're going to apply Esther.
Esther, are you aware of, because I've told you the land is held under customary law. So you're aware of the act called IPILRA, Interim Protection of Informal Land Rights Act, passed in 1996, renewed every year by the Department of Land Affairs?
I must be honest and concede and say no.
Yes. Now, then, question 2.2. There is a community, let's call them Community X, they're called Bakhatla, Bakhafela. There is another community within Bakhatla. They're called Bakhatla, Batolwane. The sub-community wants to have a meeting because it wants to discuss whether it should secede from the broad tribal community, Bakhatla, Bakhafela. And there's an interdict brought to stop the meeting because the view that's taken by Bakhatla, Bakhafela is that everyone who belongs in this community can only meet via the king or the traditional authority. What law would you apply in resolving that dispute? And which case can you think about? From the Constitutional Court as well.
I've drawn a blank.
Yes, well, the case is Pilane and the law is customary law.
Yes.
The reason I'm concerned about this is because that area where you are going, the Northwest, firstly, the majority of the speakers there, they live under customary law. A lot of legal disputes are disputes that put into conflict the provisions of the mining legislation, customary law, and IPILRA. And you seem to be, let me say, not knowledgeable about any of these substantive legal provisions, but they constitute a substantial amount of litigation happening in the Northwest.
Your point is well made, Commissioner, and I will take it upon myself to ensure that I sharpen those skills in those areas.
Thank you, DCJ.
DCJ, with your permission, just a follow-up. Thank you. Mr. Reddy, go to your list of cases that you submitted. Look at number 3. If we are on the same page, paginated, page 89.
I don't have a paginated bundle before me, but I'll try and find it in my own. If JP can just...
Maybe just to save time. Number 3, you have list Bagatla Bagavela Property Association versus Bilani and others, in brackets M450/2021, square brackets 2023, ZANWHC 62, and the date in brackets 25 May 2023.
If JP can just please repeat the page
Number 3. Paginated, page 89.
Yes, JP.
What was that case all about? Because you have listed it in your list.
That was the one that I referred to, which was resolved on a point in limine.
Oh, okay. Thank you, DCJ.
Thank you, JP. Are there questions from the virtual platform for the candidate? No.
Thank you, Justice.
Thank you.
No, thank you, Justice. DCJ.
Thanks, colleagues. Mr. Reddy, Magistrate Reddy, do you have questions for us?
None whatsoever. Thank you, Deputy Chief Justice.
All right. Well, we've reached the end of your interview. Thank you for making yourself available for the position, and you're excused.
Thank you. Thank you to the commissioners.